on the ground that the decree is a nullity having been passed against a dead persons. We are the legal heirs. We are not substituted. The judgment mentions that the legal heirs are on record. In fact, there was no substitution, no legal heirs on record. Now, after I received the summon in the final decree proceeding, fixing the measurement to fourth, I have filed the review petition immediately, and now I am making a mention. I am praying for tomorrow. Otherwise, my lord, the day after tomorrow on 4th, I will be dispossessed. That is the difficulty, my lord. And this is against a dead person, your lordship. Your lordships have been pleased to hold that decree against a dead person is a nullity.
But will it be entertainable in the review?
Yes, my lord, because it's a nullity. The court proceeds on the premises that the legal heirs are on record. In the judgment, it is mentioned.
You satisfy me tomorrow, sir.
And
I have a doubt there to satisfy. Okay, anyway, we'll see tomorrow.
It will be, I will show to your lordship that the decree is a nullity and we are the heirs and we are prejudice. Had our appeal been had.
There you may be correct, but whether in a review jurisdiction it can be.
Because that has to be ignored. That's all. I will cite your lordship authority on the point. And one more mention, my lord. There was a criminal appeal which on my mention it came. And I have been trying to conduct it, but before me there were some criminal appeals hearing which.
Oh, it will be included in the weekly.
ମୁଁ କହୁଥିଲି ଯେ ଯଦି fifth ରେ ବି ଯଦି ନିଆ ହଉଛି.
I have fixed many matters. I have already fixed many matters.
ସେ ଜଣେ କହିଲେଣି ଜୁନିୟର ମାନଙ୍କ ପେଟରେ ନାତ ମାରୁଛି ନାତ ମାରୁନି ଆଜ୍ଞା.
ଜୁନିୟର ମାନଙ୍କ ପେଟରେ ନାତ ମାରୁଛନ୍ତି.
ସେ ଅଛନ୍ତି ପ୍ରାୟ ଏଠି.
ଦିଟା ମେନସନ ସକାଳୁ.
ଆଜ୍ଞା ଏଟା କଟି ଯାଇଛି ଲିଷ୍ଟ ରୁ.
What he says is something very serious.
But when he does it, ସେ ନାତ
you
ମାରୁଛି.
sort it out outside, but you seniors are not allowed to mention.
On being requested. The associate is there.
Seniors are always requested only. Senior doesn't hold any brief.
No, on being requested.
Seniors only on the request of junior counsel you appear.
He has requested. He has requested.
You take revenge on him, but
भाई सबले भगारी होंती
Or senior shouldn't mention. He is right there. Right. Encourage juniors. You stand.
Achha, he is there. To
appeal, you will mention at 2 o'clock. He will mention at 2 o'clock.
Yes, to know the articulate of mentioning.
Today at 2 o'clock, he will mention regarding appeal. Okay, you come and mention. Okay.
Pardon, my lord, it was in the hearing list, my lord, but he could not sit there. And for the last 2 to 3 weeks, it has not come.
You please
very urgent. A matter of 2013, related to vigilance appeal.
Appeal, na?
Appeal, related to vigilance.
Anyway, we'll
my lord, fresh admission. NBW
press medicine.
I may
that is date of being dispossessed. The fresh set has not been admitted.
2023 matter.
Or 31 and to CPC. Date of dispossession.
How can you adjust that? Yes.
Any mention from item?
No. There is a mention here. Yes.
CRLMC, my lord, 1260 of 2025, wherein warrant of arrest have been issued by the executive magistrate. So I pray.
Warrant
of arrest.
NBW, cancellation of NBW.
No. Oh. Cancellation. It's like.
Give the memo. Give the memo. Okay. There must be some reason behind it. Give it.
Lordship on CRLMC 2416 of 24. This case was listed on 19/3/2025, but could not be taken up. Maybe tomorrow.
Give it. Not tomorrow. We'll see that. Yes. Start.
The mention of item number 1 to 9.
Item number 9, my lord. Kindly taken up 1 week after.
9 request.
Item number 4, my lord.
Yes.
Item number 4, my lord. I am not prepared, my lord. Lordship may fix to some other date, my lord.
4 and 9 both, huh? On the request. Yes.
Item 10 to 22. 23 to 30. 31 to 35.
Item 33, my lord, on behalf of Mr. Bibu Prashad.
33.
Pay for
withdraw. Yes.
33.
On the
36 to 42. 43 to 51. 52 to 59.
number 45.
It will be taken up. You want
45.
adjournment? Are you interested in adjournment?
Yes,
45.
45.
Why are you seeking? You are in person.
Yes, my lord. In person.
What do you want?
Today,
Today you don't want to hear.
I want to submission my point.
Okay, I'll
my-
take it up. I'll
Okay.
take it up. Wait. Yes.
My lord, this case.
I'll take it up. Wait. At the turn. Only if you want an adjournment, it's all right. Otherwise, wait. Yes.
Item 60.
I'll take it up today, very less number.
Item 1.
But before your lordship starts with item 1, I may be pardoned to mention one matter CMP of the year 2022. Your lordship, that has not been taken up for last 2
You
years.
give the memo, see. Huh? Yes. Yes. Item.
Item 1.
Item 1 is a matter your lordship has already dealt with and identically same co-accused persons. But I take the liberty to hand over all the past ones. In fact, those are the two cases of license. Lordship may just to refresh and remind my lords, the liquor was transported backed by a permit, backed by the licensee. There is nothing wrong in the liquor with beverage corporation transported, permission was there, route is there, everything was there. But during election period, this was transported. The driver, since the night time, parked it inside a closed premises. Driver parked the vehicle since this was night time, apprehending danger. He parked it in a closed premises. That's all. Now the excise authorities went there, raided and seized, submitted a PR. Your lordship, in case of 2 licensees, has been pleased to pass this entire case on the basis of instruction given by the same.
What do you say? Then shall I? Yes. This gentleman is also similarly
He is
situated.
the owner of the truck, not the driver. They are saying that the case is made out against the driver, not against any other person.
Who is he? Mukesh Deshwal.
Case 5,
Sibo Prasad Padi is quashed.
licensee say.
Licensee.
The
And
other is also, Ramesh Soni is also a licensee.
which one?
I would case it. So ମୁଁ ଗୋଟେ ଦେଇଛି ଆଉ ଦିଟା ଅଛି ଆଉ ଗୋଟେ ଅଛି ଏଇଠି ଆପଣଙ୍କ ପାଖରେ ଅଛି ଦେଇଦିଅ
He is the driver.
No.
Sorry, he is the
he is
owner.
the owner of the entity, not the driver. State is saying that the case is made out against the driver.
Who was Ramesh Soni?
To another license, the stock of 2 licenses were being
Give it back. Ramesh Soni and Sibo Prasad Padi. Ramesh Soni is one of the licensee.
Those 2 are licenses. The present petitioner is the owner of that vehicle.
Achha. Covered? Covered? Okay. Covered. Please correct me. He's the owner. Petitioner submits that the petitioner is the owner of the vehicle. Huh?
Right. Vehicle Tata truck hearing number OR 16B 5255.
Owner of the vehicle.
Page 5 of your lordship.
Page 5 now. And the case of the present petition is that be covered by the order of this court dated 10/3/2025, passed in CRLMC number 2583 of 2024. Ramesh Soni versus State of Orissa, and 10/3/2025 in CRLMC number 2584 of 2024. Sibo Prasad Padi, State of Orissa. Both Ramesh Soni and Sibo Prasad Padi are the licensee, whereas the present petitioner is the owner of the vehicle. Therefore, the case of the present petitioner is directly covered by the orders of this court dated 10/3/2025. Also,
Same case.
submits that indeed the case of the present petitioner is covered by the order of this court. This has attained finality. And we further submit that the order of this court mentioned above, passed on 10/3/2025 has attained finality. The state has not challenged it.
Where CC case be quashed.
To a CC case. Yes.
Great.
Same type of order.
Right.
Thereafter, I'll put that.
Right.
Item 2. This is a Belgium matter, your lordship. NBW was passed on dated 4/1/2024.
Yes.
This is a Belgium matter, your lordship.
Belgium?
Belgium matter.
Okay.
Order of NBW is 4/1/2020.
4/1/24 NBW bail.
Bail, I could not able to get that because when
Sorry.
I could not able to get that Miller. Kindly allow
On bail.
regular bail.
What the petitioner submits that the petitioner was on bail. However, due to his default in appearance on 4/1/2024, NBW is finished.
Yes, sir.
Correct. Item 3. 500. Yes.
May I please, your lordship, my lord. Here this matter, my lord, that the matter has been settled between the parties. Informant and injured are two different persons. Informant and injured two different persons. I have made injured as a party opposite but not two. And I am giving, my lord, this is the informant, my lord, that I have made opposite but not three, my lord.
So you want to amend the party, huh?
My lord, informant as a
Right.
opposite but not three. So otherwise,
Petitioner, counsel for the petitioner seeks leave of this court to implead the informant as actually informant or injured, huh?
my lord,
3 is informant or injured?
informant, my lord.
Informant, of opposite party number 3 may do so during the course of the day. Issue notice to opposite party number 2 and 3.
My lord, brother already appeared on behalf.
Appearance for both. Appearance undertake to file whatever is the matter.
Just keep it.
Parties filed in the court of taken.
If it to undo, my lord, that all the party will appear.
Fix the data. Okay.
My lord, I have miscase, my lord, interim stay, my lord. They were on bail, my lord, but if matter will be complete, my lord, I will trial.
The counsel appearing for both the parties conjointly submits that the parties have settled the issue. Hence, he prays for the stay of the further proceedings pending in the court. Which court?
Court of
307 is there.
Special
307. What are the injuries?
Two injuries, my lord, there. One is, my lord, grievous, other one is simple, my lord.
Then which part of the body?
Belly, my lord. Belly, my lord.
What is the weapon used?
My lord, that is
Weapon used.
weapon.
No, type or not. 307 is not casually you can.
No, my lord, though, not no, my lord. That is, this is the injury.
One, there is a grievous injury also.
Yes, my lord, one grievous injury.
307.
So far,
Let him move application for it while considering. What cutting the weapon or something? No, it has to be seen. No, don't press the notice for state. Yes. Grievous I'll see. I'll have to examine. Whether it can be quashed or not, that has to be seen. 307. Yes.
Item 5.
Yes.
And the party will appear, my lord, on that day.
That is your problem. I will not insist the party to come and appear. I'll have to consider that day whether it can be quashed or not. Then only. Yes. 307 grievous hurt, and you have used weapons, deadly weapons. Yes.
Item
Yes.
number
Short dead, my lord, so that party.
Sorry. Yes.
Item 5.
5.
Petitioner is challenging the order under Annex 1, my lord, where the application under 311 was rejected on the
300?
ground. 311 application has been rejected under CRPC on the ground
1, 2,
that
3 and 10.
yes, 1, 2, 3 and 10. I've already submitted the evidence copy. I only want to ask 3-4 questions I have quoted in my petition, and your lordship see at page 11 of my brief. This is a case arising out of a small issue with regard to death of two hen of the neighbor of the informant. There is a village meeting continuing under the chairmanship of this present petitioner, and during the meeting, this dispute started. That's some hot exchange of words. Then it leads to a death of the deceased. Not immediately, he was immediately shifted to several hospitals. Then he succumbed to injury after 2-3 days. Initially, case was instituted under 307, subsequently converted to 302. I only am asking these questions. No prejudice would be caused to either of the parties. When I am facing a charge of 302,
Now, what
though
are
it is not a case of
what are
302.
the questions you are?
Question, my lord, I am asking, you will also kindly turn to page 11.
Yes.
At the time of the claims that at the time of this so far as PW1, at the time of inquest, he was present. In fact, he was not present. This question was, he had never disclosed before the police during investigation. I want to confront that. And what is the educational qualification? Because some other person had written the
Just
affair.
have you checked it whether these questions were put to them or not? He has filed all the evidences. Have you checked it up? Opportunity are given whether these questions are directly or indirectly put to these witnesses already or not. That has to be seen. I will not keep on examining everything.
Already 3 adjournments they have taken, my lord. I don't know.
Pass it over. Pass it over. Read it and tell. Otherwise, I will allow you tell which witness is important. Because they suffered very extensive cross-examination. Very extensive cross.
But these pertinent questions,
You might not have what are the reasons for not putting it? You can't be wiser at any time and move up.
no, that's true. Simultaneously, it is to balance, my lord. No
So
prejudice is caused.
therefore you choose. Therefore, you choose which is the main important witness.
Yes, my lord. 1 and 10. Yes. 1 and 10 are two near relations. They are claiming to be the eyewitness, though in fact they are
1
not
and
there.
10, you just examine 1 and 10. Whether the questions, scheduled questions which he has put it at page 11, or those questions were already put to 1 and 10 or not.
That is not. You will
Already
record my
then
submission.
I will not. You check it
Had it been there, there is no occasion for me to make an application on 311
No, pass over. Do it small matter.
before rising.
You should have done it. This exercise has to be done by you. It's more of a reason 302, therefore he is entitled for recalling. He is facing 302. He has a right to cross-examine and right to defend. Yes.
Item 6. Please, my lord. I am on VC, my lord.
Yes.
I have prayed for quashing of the order of cognizance and subsequent issuance of process, my lord, as per your lordship's last direction. This matter was settled, my lord, between the parties, and the agreement is at annexure 4, page 31.
Where are they?
They are here, my lord.
Big
3,
immoral debt,
yes,
not recoverable.
yes. Here, my lord,
What is the fact?
the fact remains, the petitioner number 1 is having some landed property. When she came to know that this opposite party wanted to purchase some land, petitioner number 1 along with petitioner number 2 went to his place and offered him. So
No, wait, you show me in the complaint whether it is see those in that case facts are admitted.
yes,
Here if the disputed fact it has to be established.
my lord,
Show me from the complaint how it is immoral debt.
my lord, kindly see.
A check issued towards recovery of immoral debt. is
Yes,
not,
by the petitioner number 3.
Yes, that you have to.
My lord, kindly have a glance.
Which paragraph?
My lord, paragraph 16, page 18, my lord.
16 of yes, 16. Yes.
As all the accused person have ultimately failed to keep the promise and assurance given to the complainant at the time of agreement to obtain the required permission from the competent authority.
What is immorality about it?
My lord, yes, my lord, kindly after 10 to 12 lines, my lord, 3, 4, 5, 6, 7, 8, 9, 10.
No,
11,
you are not covered with it. I read it.
13 line, my
I read it.
13 line, my lord.
See, the fact of that case is different.
Ultimately, after
The fact of that case is the for the purpose of getting admission in a medical college,
yes,
the
son has
money
taken
was
some-
paid. They could not arrange the medical seat.
Subsequently, mother has
he
issued a
returned
check.
the money by way of check, which was
Yes.
dishonored.
Yes,
Then I said that since you participated in the illegal act, so it is not recoverable. So 130 doesn't lie. It is the immoral debt. That was the fact. Here there is an agreement.
my lord, agreement between the petitioner number 1.
This is dispute.
I am not saying
Where
that,
is immorality? You tell me.
My lord,
Enforceability and legal
My lord,
enforceability
here-
is something different.
here, my lord,
Immoral.
the check was issued to petitioner number 1. As he is not having an account in her name, it was again issued to in the name of petitioner number
Was
2.
there any valid transaction?
Yes,
Transaction was
Yes.
there? Then where is the immorality?
my lord, immoral, so far immoral part is concerned, my lord. When they are failed to give the property,
Then every criminal.
the son has issued a check. Son has issued a check and which was bounced. And my lord,
Where is the immorality about it? I
and
don't-
we have already, my lord, paid 1 lakh to him.
That is a different story.
And will also issue notice, my lord.
No, no, no. First of all, the judgment which you have brought here completely distinguishable. Nothing to do with it. This much
My
of
lord,
not.
the son is not at all involved in
Something different.
any of the transaction.
What is the check amount?
My lord, 2,50,000, and we have already refunded 1 lakh, my lord. And you'll also may issue notice, otherwise you'll also may say for the counseling center, my lord, to attend the.
You deposit 20% and go.
My lord, yes, I am ready to do.
Right. Subject to petitioner deposit. The check amount is 2 lakhs?
2,50,000, my
2
lord.
lakh. Petitioner is challenging the order dated 7/8/2024 by the cognizance of offence under section 138 NI Act. Read with section 318.
18,
One-
yes, yes.
1 bracket 3(5) of BNS Act 2023 has been taken against the petitioner. At the outset, petitioner submits that he is ready and willing to settle the dispute. Regarding head to the statement, the petitioner issue notice to the opposite party, subject to petitioner depositing 20% of the check amount. Check
Lord.
amount. Shall I send it to High Court mediation or somewhere else?
My lord, you'll also may say
Raigada District Court.
Gunpur or Bisamkatak,
So Raigada I will send it.
my lord.
Raigada, huh? Send it to Raigada Mediation Center, District Mediation Center, Raigada, awaiting the mediation report. Release the matter on so. In the meantime, the coordinator of Raigada District Mediation Center shall fix a date and intimate the same to the opposite party. For exploring the possibility of settlement, awaiting the mediation report, release the matter on so. In the meantime, proceeding before proceeding before which court?
My lord,
JMFC.
JMSC Bisamkatak.
Bisamkatak in 1CC case number 4 of 2024 shall remain stayed subject to the condition. Subject to the petitioner depositing 20% as stated.
May I pay 10% because 1 lakh I have already paid, my lord.
I'm only exploring the possibility of settlement. Yes, next.
So judgment.
Item 8.
Yes. 8. Huh?
This is not 311.
What is their password? Password. What is it?
Item 10.
Yes.
So the one cause that is not two case LLC. One is LLC police case by another person and another person file complaint case LLC. This case is arises out of acute civil dispute between two families LLC.
You are seeking quashing of the 1CC case.
Yeah, the order of the order of let me allow. The order of cognizance also 30th 9/2024 page 18 LLC.
Yes.
My respectful submission first of all a glance so far as the page 32 the FIR LLC. Soon after that the case and counter case there is no doubt that arises out of a civil duties LLC. Soon your lordship the FIR LLC.
307-354 is what civil about.
That I am coming lordship. So far the FIR LLC 32 is concerned lordship. That is will register 294, 323, 341, 114, 34B, 506, 34 opinion penal code.
Jaleshwar PSK.
Jaleshwar PSL, space 32 lordship.
Yes.
And they are the informant lordship, one Romarani Jena lordship. They are the informant. Although in the FAR, it has been stated that we have been assaulted mercilessly and admitted in hospital. But during the course of investigation, the police has never been found no such clue, Your Lordship. Accordingly, charge sheet of the case has been submitted for the offence, Your Lordship.
It's all right, huh?
394, 323, 341, 114, 350, 506, 34 IPC, Lordship. Your Lordship, this case registered also 3/12/2023, there is occurrence, date of occurrence. FIR, Your Lordship, 5/12/2023, Your Lordship. Then Your Lordship came to the complaint case, Your
Who
Lordship.
are the petitioners are the accuser?
Yes, there, Your Lordship, charge sheet so far submitted only three accused persons, Lordship.
Who has filed, who is the complainant in that case?
That this FIR also complaint is Ramarani Jana, Your Lordship.
But in your, this
The
case.
complaint, Your Lordship,
Kalpana
is Kalpana Bhuya. Same incident, Lordship, the two persons are the different persons, Your Lordship. One FIR lost by Your Lordship Ramarani Jana, another complaint lost by on 19, that has been lodged of the complaint, Your Lordship, lost on 19/2/2024, Your Lordship.
Pertaining to the same incident.
Same incident, Your Lordship. My respect to submission. Yes, Lord.
Page 30. Come to page 32.
Yes, Lord. Then a page 32, Your Lordship.
Understand what he says.
Page 32, Your Lordship.
Date of incident is
3/12/2023,
3/12/2020
Your Lordship.
at 5:30.
At 5:30, Your Lordship.
Come to the complaint.
Complaint petition, Lordship.
Yes. Come to the complaint.
Here, Your Lordship, the complaint name is different.
5:30.
Only one complaint name is different, Your Lordship. Kalpana Bhuya, there is Ramarani.
Kalpana Bhuya.
Ramarani. Here is the date of occurrence 3/12/2023. Then Lordship occurrence time is 5 Your Lordship.
5:30.
5 p.m. 5:30, I can call 5 hochi.
No. Come to page 12. 5:30 AM.
Yes.
Hmm.
The page 12, the initial statement, Your Lordship.
Page 13 is the day.
Page 12, the initial statement of the complainant. My grievance is that, Your Lordship, if there is a two case, Your Lordship, that is one is complaint case and another is police case, Your Lordship. And this complaint case, the FIR, Your Lordship.
Yes. What is
I have been instructed to appear on behalf of the informant. By tomorrow, I will file the Vakulatana. Lordship may direct the petitioner to supply a copy to me. And
that I'll do, but the fact is there are two incidents takes place at the same time.
Ramarani is the sister-in-law of the Kalpana.
So that
all were asserted. All were
so how
asserted.
can there be a two FIR? One complaint.
Not two FIR. One FIR and charge sheet was submitted. I am showing that my lord only charge sheet portion, my lord. Why the complaint case was later, the complaint case was.
Yes. So
Lordship may
Not that letter.
1 minute. 1 minute. Close the report filed for some few of them.
My lord.
Therefore, he filed a complaint.
Then my lord is fine.
As they disclosed in the complaint, it is a protest petition, Lordship, never been. If Your Lordship, the closure report has been filed and the closure report does not has a recurrence with their sweet will, then there is a procedure they have to file the protest petition, Lordship. This is not the protest petition, Lordship.
My lord, kindly see
And
the
if
charge sheet.
Your Lordship a glance, the court hold that it is a two case, Your Lordship, then 210 CRPC has to be followed first of all. Nothing, Your Lordship. And so far the medical document, Your Lordship, the complaint case does not disclosing any medical report has been filed, Your Lordship. Latest details been manufactured, Your Lordship, then submitted before the court, then 327.
Simple cheater complaint.
No, my lord, simply a complaint and it was stat. That complaint case and
Okay.
FIR it was
I
stat.
issue notice. Mr. Mishra accept notice. And undertakes to file Vakalatana on behalf of opposite party, number so and so. And Mr. Mahanti accept notice for the state, release the matter for hearing next week. Come with it. I think both the matters has to be tagged together and
It has already been tagged, my lord, because in the cognizance order it has already been tagged.
we'll see.
And then my lord, kindly see for a moment that charge sheet, my lord. Only one to one,
Charge sheet.
one line, my lord, charge sheet.
Charge sheet has never been made before the my Lordship
My lord.
record.
He has not filed charge sheet.
Supply, I do not know whether charge sheet is there or not.
My lord, I am
You file the charge sheet partly.
Supply me so that I can say.
Yes. You must be
reading.
having a charge sheet.
The IA is there, Your Lordship.
Oh, he is there.
Today the date is fixed.
No,
My Lordship,
Why that
Can't be
cognizance?
changed because there is
the court will Lordship proceed for NBW. No course at least till
NBW will pass immediately.
Lordship, I may be arrested in the minute. It will be in fluctuations.
My lord, anticipated by 3% was allowed, 3% was rejected.
Rejected.
It was 10/3/2024 and anticipated rejected.
Application for it.
Obligation.
Yes.
My lord, if your lordship will say the.
That has been fixed, your lordship.
I will not stay the proceeding. I know that. I will not stay. He will move application
For adjournment, your lordship.
for adjournment. Yes.
Development.
Yes.
11.
Because here, the cognizance was taken in 2017. Now 2024, the trial is in very early stage, Milords. I'm just praying for targeting the time. I'm not pressing my.
When the FIR was raised?
The FIR was raised, Milords, on 22/4/2017.
17.
Yes,
Charge sheet
Milord.
filed on?
Charge sheet filed on, Milords, 27/5/2017. Milords, just college students. College where ticket nothing. Now they are giving
What
exams.
is the stage now?
Now, Milords, PW1 was examined on 28/8/2024.
So things are going on.
Yes, Milord. I'm saying just target, Milords, because they are giving
How
exams.
many? I don't know how many witnesses to be examined. Nothing is there.
I am not there, Milords.
How many witnesses?
Milords.
Charge sheet witnesses. Where is that? Target is not casual target. We have to be practical. Pressurizing trial.
I understand.
No,
It's not,
you know.
Milords, what my predicament is.
You tell me how many witnesses have target means what?
Charge on
So, already
Yes.
witnesses.
That's why, Milords,
How much?
Milords, I know, Milords.
First of all, you came very late.
Yes.
You have come little early.
I'm not pressing my application even. I'm saying just college students, Milords, they're giving exams, government exams. One of them
I
has qualified.
understand their predicament, but okay, right on.
That is my only predicament.
Petitioners are seeking. What are you seeking here? Cussing.
Crossing, Milords. I'm not pressing.
Although the petitioners have assailed the entire criminal prosecution initiated against him in connection with Mangalavaga PS case number 90 of 2017. But counsel for the petitioner at the outset submits that he would not press the petition. Rather, seek indulgence of this court for a direction to the trial court for expeditious disposal of the trial. He particularly makes this submission on the ground that the petitioners are young students and pursuing their career, for some government job due to pendency of the present criminal prosecution. They are not able to their career perspective marred. Hence, he seeks indulgence of this court for early disposal of the trial. At the same time, the counsel for the petitioner submits that out of 4 charge sheeted witnesses, one witness has already been examined. Next paragraph. The present case is rising out of FIR registered on 22/4/2017. The charge sheet in the case has been filed on 27/5/2017. Since then, since last about 8 years, more than 7 years, the trial is going on. There is a result of which the petitioners' areas. What are the offences, by the way?
The offences is 341, 294, 323.
Very minor offences.
Yes, Milords.
Then we can give you the offences. That is 341, 294, 323, 506, 34. Regarding head to the nature of allegation and the fact that the petitioners are young students pursuing their career, I am up for the view that the trial court should be able to see that the trial of the present case is included the age at least is possible, preferably within a period of 6 months and 6 months. And it is made clear that neither the defense nor the prosecution shall seek unnecessary adjournment before the trial. Right. With this observation, petition is disposed of. Yes.
That's highly obliged, Milords. I am highly obliged.
Well. 30.
Yes, my lord. Petition challenging the order passed by the JMFC Kujang under Annexure 1, my lord. Kindly glance Annexure 3, my lord. Earlier the petition approved this honorable court and honorable directed to deposit 20,000 rupees, my lord. Annexure 3, page 19, my lord. The last part of operating part. Here, my lord, the London session judge has directed to stay the further proceeding, my lord, in DB case, my lord. But the JMFC has issued the order and production the accused, my lord.
What exactly
Annexure 3, my lord, page 19, my lord.
Annexure 3 is in view of the
Last paragraph.
order of the
In view of the order, honorable court advocate for the appellant deposits sum of 20,000 rupees. By challenge so and so. The further proceeding execution case number 10 by 22 of the court of the JMFC P. Kujang shall remain stay till dismissal of the criminal appeal 10 by 22. Call for answer giving discussion of so and so from
Yes.
the court of London.
Yes. Then what happened?
Can glass annexure 1, my lord.
Yes.
Here, my lord, the JMFC.
Which
Lord
order?
Counsel for the OP file a challenge for 20,000, which is deposited in view of the order passed by the Supreme Administration is accepted, put up on 6 services for production of the OP and further order, my lord. Production. Receive the
No,
challenge.
you read further. In the event the petitioner has been deposited the sum of rupees. This was the order.
Last order, my lord.
1 minute. This was the order. Disposal of criminal appeal. What happened to the criminal appeal?
Criminal appeal is pending before the session judgment. A kind glance, page 13, my lord. Last order, 2524, my lord.
20?
2524.
Yes.
Page 13.
Page 13, my lord. Lord Counsel for the OP file challenge of 20,000 rupees, which is deposited in view of the order passed by the 2424 CRLC 257/23, and the same is accepted. Put upon such services for production of the OP, my lord.
Then what happened?
Here, my lord, the session already granted the stay order in the appeal and execution stay, my lord.
So this is an order till the disposal of the appeal. Hey, what is wrong in it? You go and appear. What is the big deal about it?
Well, here the production the appeal and that basis, my the police is searching me, my lord. After granting the stay by the honorable High Court passed the order directing the session judge.
See, it is not a complete stay. It is only till the disposal of appeal. And the proceedings day to day.
Stay of the further proceeding, my lord.
I know. This where have you said that the police is searching you? Where is the NBW? If police search for some other case, how do I know? Where is the NBW? Why should police will come in?
NBW is no, my lord, but we are searching, my lord, because of that.
If there is an NBW, then police will search.
Production is only the production what is, my lord.
I don't know what kind of. Where have you said that the police is searching?
That information,
where have you said that? You tell me at least. Tell me where have you said. You dream something and what can I do? You have dreamt it, it seems. Where have you said in the petition that the police is searching and I can give intelligence? Where is the threat? There is nothing. Where have you said that? Who is searching you? Why they are searching you? And otherwise there is no, there is no prejudice. You go and appear. You have not said anything. You have drafted, where are you searching? You must know whether you have written it or not. You have not written, sir, anything anywhere. That's the problem with you. You have narrated the entire facts, but when it comes to the impugn order, para 10 onwards, read.
Impugn order, my lord, honorable High Court, my lord. Impugn order, my lord, page 13, my lord.
You say that the order of JMFC is illegal, whimsical, strict violation of the order of this court, so and so. That's all. According to me, it is no violation.
No,
where is the violation? It says only till the disposal of appeal. And court says that come and appear.
As per this,
you will adjourn it. Go and adjourn it.
Honorable High Court order, my lord, the session could accept.
This has been noted, sir.
And directed to JMFC to take further proceeding.
I think I need not.
Stay further proceeding, my lord. He has a.
I may not be, proper to interfere in this kind of. Okay. Simply withdraw and I will see that. Then counsel for the petitioner is
Next
agreed.
my lord, I
1 minute,
Next week, my lord,
I'll clarify it for your
My lord.
advantage. The land counsel for the petitioner is agreed by the order dated 2/5/2024 passed by learned JMFC. JMFC fixing 6/7/2000. That date is also gone. 6/7/2024. Date was fixed on 6/12/7/2024. Thereafter, any order is passed. Where is the proceeding dated 6/7/2024? See, put up on 6/7/2024 for production. What happened 6/7/2024?
Next week, my lord, I have a file the affidavit.
Yeah, no, I'll just dismiss it. See, nothing. What happened on that day?
That is simple.
Then this petition is nothing now. The land counsel for the petitioner seeks to withdraw this petition to file a fresh one with particulars and relevant documents. Liberty is granted to the petitioner. You file a fresh one.
Okay.
Make government, file the orders, nothing is filed. It is already infectious. 6/7/2024, the production date was. Today we are in 2025. You are challenging that order. You file a better one with that further this thing and the subsequent orders and all. Yes. 14.
Limited grievance is that on my report, the FIR has been registered under section 440, 323, 506, 25, 27 SARS Act.
Yes.
Thereafter,
You are the informant.
I'm the informant, and it was closed without giving any notice to me. Thereafter, the court has repeatedly passed orders to issue notice, press notice, but without any remark on how I received my lord, they have closed the case. Now, in a similar circumstance, similar matter.
I am appearing in this case, my lord, for the accused persons. Notice as due.
Thereafter, in similar cases, same court has passed identical orders, without verification of record. This is the order, my lord, lordship passed in the same court, identical matter, same day, same manner. And lordship has directed me to file a protest. You gave the liberty to file a protest petition within 15 days, unfailingly, and it will pass. The court will pass the order in accordance with the merit. That is the order. I have.
Notice was duly served, but this is the certified copy.
No, it's all right. What he says is I have to appreciate
Notice was duly served.
Normal SDGM code, no problem. In the Lok Adalat, this can be closed. It can't be closed.
My lord, kindly have a glance. The order dated.
Sir, I understand last order is just the order is passed by the Lok Adalat. Try to appreciate. 13/5/2023 is an order passed by the Lok Adalat.
Yes, my lord.
Can the Lok Adalat pass? This jurisdiction is there with the Lok Adalat.
No, my lord, notice was duly served on the complainant.
That is
but he has received the notice, but denied to give the signature.
That is a different story. The normal court can pass. Normal court having jurisdiction, but not Lok Adalat. Let it go to the normal court, the same order be passed. No problem. You tell sufficient opportunity is given.
Kindly have a glance to see whether the notice was
I understand
served on me.
I understand, but can the Lok Adalat pass this order?
Kindly have a glance.
Problem is Lok Adalat. Otherwise, the order is absolutely correct. Perfectly correct. There is no doubt about it. But Lok Adalat can't pass.
That may be, but notice has duly served on the complainant.
That is what he says. How the Lok Adalat has got the jurisdiction. Normal, the same SDGM exercising the power of SDGM could have done it. And he could not have challenged it. But Lok Adalat. That's the problem.
Notice was duly served on 5/2/17.
I'll simply set aside and I'll tell that let the SDGM.
After 2 years of the.
I know you
after 2 years, my lord, the complainant has come to the Supreme Court.
Do you need further debate in this? Lok Adalat doesn't have jurisdiction. I'll set aside and place it before SDGM to pass appropriate order. That
Yes,
time
my
you
lord.
go and tell what.
Yes, my lord.
No, I'll set aside and set it.
Yes.
Right. Petitioner is agreed by the order dated 13/5/2023, whereby the SDGM Devgod, while sitting on the National Lok Adalat, has passed the impugn order, closing the opportunity to the petitioner, who is the informant, to file the protest petition on the ground that despite valid notice served of the petitioner oblique informant, he has chosen not to file the protest petition and not to file the protest petition. Counsel for the petitioner submits that the local adalat has no jurisdiction to close the right of the petitioner oblique informant to file a protest petition. The so appears for the opposite party and submits that
My power may be
service on the
Power may be entertained,
court
madam.
has recorded in the previous proceeding, court has recorded that the service proceedings, previous proceedings, court has recorded the sufficient service on
Yes,
the
recording.
opposite parties, on the petitioner. Hence, the order passed by the impugn order is justified. I'm in agreement with the submission made by the petitioner that Lok Adalat has no jurisdiction to pass such order. Therefore, the same, therefore, the impugn order dated 13/5/2000. What is happening? Who has done it? Who is this gentleman? Who is he? But who is he? No, actually, our staff. Okay. Jurisdiction pass the impugn order. Hence, the impugn order dated 13/5/2023 passed by ATJ Devgarh while sitting as in the Lok Adalat in city case number 883 of 2016 is set aside and the matter be placed before the SDGM Devgarh to Devgarh to pass appropriate liberty granted to the parties to raise their points before the SDGM Devgarh when the matter is to be heard by the court. Yes, with this observation, petition.
The power may be entertained.
I understand what you are trying to say.
No, sir.
I have done it, but there was no opposition. Now there is an opposition.
No, opposition, sir, it is.
It's all right. I have now tell all these things.
One sentence, sir. ये जो एंटायर ऑर्डर सिस्टम है सर
I satisfied that order.
हां ସେଥିରେ କୋଉଠି सर्विस କଥା आपण लिखले सर्विस କଥା कोउठी नाही से लिखा है कि ऐसा नोट
There is an opposition. I am satisfied. Go and tell the all.
सर खाली with a where to file a protest.
I am
You go and tell that to
certified copy.
go with the protest petition. You lent it in.
I am filing the certified copy.
One line of it.
Shall just so. Yes, next. 15.
My power may be entertained, my lord.
No power here. His power of power. Yes.
My lord.
There the problem is the one problem you have to face it. There is an SR report in his favor. That you check it. I just am telling you. I am not saying anything, but you just check it. Yes. There is an SR report.
Yes, sir, not back.
SR not back, কিন্তু এটা sufficient হয়েছে তার SR not back.
Anyway,
order
I pass the order into. Yes.
The petitioner, 15, my lord, and the petitioner challenge the order of cognizance, my lord. That is page 40, my lord. That is a matrimonial dispute. It's cognizance order passed under section 320.
I'll pass the 498.
Yes, sir.
Issue notice.
Husband and mother-in-law.
Issue notice. Yes.
Yes.
My file miscase, my lord, stay, my lord.
Remove application for adjournment. The same shall be considered. Yes.
Stay, my lord.
Yes.
My lord, in this petition, I'm filing the challenging for illegal and arbitrary order expired order dated 23/9/24 and notice dated 24/9/24 passed by the additional DCP Bhubaneswar, Executive Magistrate Bhubaneswar under section 126 BNSS.
126.
107, corresponding to 107.
Issue power. Remove. Going to yes.
Yes, madam. The fact of the case is that petitioner number 2 the old man, 75 years old man, when attending the nature calling at the time of 4:30 a.m., some foul play person of the locality assaulted by a big sword, and with a deadly weapon, right? That is the Khonda, big sword, for which petitioner 2 was
Show me the order. Show me the order.
order annexure 1, page 11, my lord, running page 11.
Yes. Who are you? Let us see.
OP2 in proceeding under section
Yes.
107 CRP shall also.
126
There is
of
no
the
matter
basis.
directed to file the show cause. To the OP.
That is only show cause. Go and file a show cause. What is the great deal about it?
My lord, in
And
this
show
case,
cause stage only you came.
Appearance to show cause.
my lord, in this
Yes.
case, order has been passed on 23 no,
107, 154.
Yes, my lord.
Proceedings.
Yes, your lordship.
My lord, in this case, petitioner, all the petitioners are the victim in this case. And there is no allegation.
Go and tell that to the magistrate.
Sorry?
File a reply. Go and tell that to magistrate. Magistrate will decide it. You have converted High Court to magistrate court now.
Well, kindly see the para 6 of my petition.
You may be correct. I am not saying that you are not correct. You may be correct, but it is a show cause stage. You go and tell all these things. If any adverse order is passed, come here. See, show cause means what? You have to show the cause.
Yes, ma'am.
You have to show cause to whom? Magistrate. Not to me.
Yes.
Go and show.
Well,
If he passes an order, if he passes an adverse order, you come here.
Well, the notice that issue against total code.
Then you convert the High Court to the magistrate court. In every case, then if they start interfering, then there is no end to it. Then we will close that and 107, everything we will deal with. Then it is only show cause. No adverse order is passed. You go and tell. I will give a direction to the magistrate to expedite the proceeding and decide it. You may be having a good case,
yes,
but this is not the jurisdiction where I should go into. Honestly, petitioner is agreed by the order dated 23/10/2024, passed by the additional DCP, come executive magistrate E.M. Bhubaneswar, whereby notices has been issued to the petitioner under section 126 BNSS bracketry 107 for CRC, calling upon him to show cause. Show cause on the for the show cause on or before 3/10/2024. Have you filed the show cause?
No, my lord. Thereafter, the notice has been served on me 16/10/2024.
Learned Counsel
After a long time.
submits that the notice, the said notice was served upon him on
16/10/2024.
16/10/2024. But he has not filed.
There is no chance to file.
Reply to the so called notice. He has raised many points assailing the notice issued by the impugn notice. Assailing the impugn notice. This court is not inclined to entertain this application being premature. Rather, grant liberty to the petitioner to file his response to the notice dated 23/10/2000.
9 years. 23/9.
Actually, 23/9/2024. 24. If the reply to the so cause notice is filed, it is expected that the executive magistrate, additional DCP come executive magistrate shall do well to decide, do well to take into consideration the defense put forth by the petitioner. With this observation, petition is disposed of. Yes. File the reply. Yes.
70.
May it please your lordship. Sentenced to undergo RI for 4 years under section 7 of the PCA.
4 years.
I for stay and bail.
7 years, huh? 7 years, huh?
4 years.
4 years. 7 years, then okay. 4 years. Appeal admitted, bail granted.
Stay relation of
fine. Let's see. Mr. Das appears on advance notice. Copy of the petition is applied to. Yes.
Play.
Then Mr. Das When you appear in VC, you shout. When you come here, you don't say anything.
No.
Soundless. What is the problem?
When I feel that it will be late, because earlier we were coming by this side, we are reaching earlier. Now we have to move from this side.
So all
So
energy
actually-
is lost by the time you come.
So I cannot attend, so I am appearing through virtual.
No. When you come here, you all energy lost. So when you sit in the home, then you.
I am coming earlier. When I am coming earlier, by this way we are coming a long route, 1 kilometer.
Oh, it's matter of couple of months.
Couple of months. It will take near about 2 to 3 years.
It's for you. You are good only.
3 years it will take.
No, not that much.
This
Maybe
side,
1 year.
unless and until that building is constructed.
Maybe 1.5 years. Maybe.
So we will have to wait for 1.5 years or 2 years.
It's for good. Wait for good. Yes.
18.
My pleasure, Lordship. In this case is for quashing of NBW, Lordship. NBW was issued in the execution case arising out of the DV miscase. In the DV miscase, the Law and Trial Court directed the petitioner
Issued in the execution proceeding initiated by the opposite party. Number?
execution of 30 of 2024.
Opposite party. Yeah? Number 1, huh? Opposite party number 1.
Opposite
Execution
party number 1.
Opposite party number 1.
2 and 3 minor children.
The NBW has been issued on 10/12/2024 by the civil judge, senior division cum ASA, Women's Court, in criminal execution case number 30 of 2024. On or before appear on 25th April and resort of the remedy. Yes.
19.
My pleasure. One thing may submit. In that case, I have filed an interim application to stay of the execution.
I have disposed it up. We are talking of state, allowing your petition.
I have to deposit it also.
You go and appear and resort to the remedy. Yes.
May I please, your Lord? My Lord, in this case, for present petitioner, for the quashing of the NBW, my Lord, previously petitioner was in bail, my Lord.
Do you have the dates?
My Lord, on dated 13/12/2020.
No, date, bail.
Bail date.
November 2021.
16 November 21 bail, 13/12/2023 NBW.
First
Yes.
time, huh?
1,000. Yes.
20.
Dispose of my Lord.
May please also, my Lord. It is arising out of 1 case, my Lord. Earlier, the BW was issued 28/3/2024. BW was issued 28/3/2024. Subsequently, NBW is 11/7/2024.
Bail. You are on bail.
No, my Lord. 1 case, my Lord.
The present case is arising out of 1 CC case number 102 of 2017. The bailable warrant was issued by the order dated 28/3/2024 for non-appearance for the petitioner. Subsequently, on 11/7/2024, non-bailable warrant has been issued against the petitioner. Was with you and 500.
Oh, bless me.
21.
My Lord, I am on PC, my Lord. Belgium matter.
Yes.
Belgium matter, my Lord. NBW was issued on
Yes, Mr. Bishwa.
1 minute. 317 petition rejected. Thereafter, NBW was
The petitioner moved an application under section 317 CRPC, which has been turned down by the Learned ASJ Chhatrapur and by the order dated 23/9/2023. NBW has been issued against the petitioner and other co-accused and 1,000.
22.
22, my Lord. The petitioner was on bail on earlier, my Lord, on 29/5/2020, my Lord. And NBW issued on, my Lord, 4/8/2023, my Lord.
Yes, 1,000. Yes.
23.
The petition was on bail on 6/11/2009.
6/11/2009.
And NBW issued on 7/6/2016.
7/6/2016. 1,000. Yes.
24.
24 bail was on 18/11/2020. NBW 19 January 2024.
24 of 500. Yes.
25.
Yes, 25.
My lord, the file was taken by the party. We have no instruction.
No instruction. Let comes for the petitioner submits that repeat what is your name?
T. Sahu on behalf of SK Samantrai.
So appears for Sanjay Kumar Samantrai. Let comes for the petitioner. She submits that there is no instruction from her clients. Hence, shall I dispose it up?
Yes.
No instruction from the client. In view thereof, the petition is dismissed. Yes, 26.
26, my lord, I filed a restoration petition. Actually, my lordship, it was dismissed for non-appearance.
How much delay?
Delay, my lord, of 707 days. Actually, the petitioner's father, he passed away after suffering a cardiac arrest. So his son was unaware of the fact, and therefore there was a delay of 707 days.
Oh, it's all right. When the writ petition was dismissed?
27/9/2019, my lord.
27/9/2019. And he died in 2018.
My lord.
1 year before he died. 1 year before. That is on 2/1/2018.
My
the
lord.
father died.
My lord.
And the matter was dismissed in 27/9/2019.
My lord.
Then?
My lord,
something which has happened prior to the dismissal. How will you explain that?
My lord, the son was not aware of this case, my lord, if you may kindly.
No, not like this. You have to sufficiently give the reasons. 2000, see, the writ petition was 1995, 1993. Huh? What is this? Writ petition was filed in 2000.
2000, my lord.
What? Arising out of what? What is the writ petition is about?
My lord. My lord, the petitioner was, it was against the IDCO, my lord. Petitioner had some machineries in the land. For the prayer that was there is shed number C7. The petitioner had some machineries earlier on lease. So after it was after the trial court ordered that the said properties they would go to IDCO, the machineries that the petitioner was using, he had to take those properties, those machineries that was there in the C7 shed. That was the original case.
Yeah. Thereafter, what happened?
Thereafter, my lord.
Now, see, 25 years, 2000 writ petition. You want a restoration, 25 years.
My lord, it wasn't deliberate or intentional. My
That's
lord.
not an issue. Issue is 25 years back, a writ petition was filed. It was dismissed 7 years back. And now you want restoration, saying that the father of the petitioner who has died in 2018 and 2019, January 2018, father of the petitioner died. And
My lord,
in
he was
2019, September, the writ petition was dismissed. After 1 year, more than 1 year.
My lord.
And how can that be a sufficient ground?
My lord, my lord Dilip Kumar Patodia.
See, I am not with you since you are appearing and trying hard. So therefore, I will simply adjourn. Prepare and come. You don't have a case. I will not dismiss it today. Prepare and come.
My lord,
the writ petition filed 25 years back.
My lord.
7 years delay. Dismiss in default. No sufficient cause.
It's 707 days.
I have to write something. I can't do it like this.
All right.
You prepare properly and come. Okay? I'll not dismiss it today. Okay. Simply adjourn. Whether in the writ petition, whether anything survives, just see whether in the writ petition anything survives. That you have to read. If anything survives, then I can think of doing it. Read it and come.
27th.
Yes. Password.
28.
Item number 28, my notice was issued to respondent number 1 and 2.
22.
28, my
28, huh?
That opposite party number 1.
Notice has already been issued. Huh?
Yes, my lord.
Sufficient.
But opposite partner one may be treated sufficient.
One sufficient.
One A.
One is sufficient. Huh?
Yes. Regarding 2, my lord, I have to take test steps, my lord. If tracking.
What is this matter? Restoration.
Readmission. But there is difference between restoration and readmission because this is in the second appeal. It was dismissed for due to non-compliance.
Who is appealing for the already served?
Because the original respondent has been died. I have taken steps for substitution.
Oh, Mr. Shogat, learned counsel for the petitioner, submits that he would take first step to serve.
2A.
2A.
Opposite party number 2A.
Opposite party number 2A. Let him take appropriate step within a period of?
Within a period of 5 working days, my lord.
5 what? Least the matter.
My lord, return date may kindly.
Yes. You do it. I can restore it immediately if the end.
Highly obliged, my lord. Within 4 weeks.
Because the second appeal.
Yes, my lord.
Has to be restored.
Yes. Highly obliged, my lord.
Take Dasti. Why don't you serve? I'll do it.
Yes, Dasti I can serve. I only knows.
Take Dasti notice. Serve.
Notice there. The person is no more available there. That's the whole difficulty.
Ex parte order can't be passed now. Like
exactly. That is what my last steps I will take. 3 weeks, maybe 3 weeks.
After 2 weeks, they give. And 3 working day, 5 working day.
3 working days.
3 working days and after 2 weeks.
Highly obliged, mine.
29.
In this case, requisites is to be filed on the question of limitation. Your lordship last occasion issued notice on the question of limitation. Due to file the
it's a problem.
Wrong noting, we have not.
You have not filed requisites.
Requisites, yes. 2 days time we will file.
Cost?
Cost. Because of wrong.
State will do like this. How to get
wrong notice.
Notice was issued by the order dated 5/2/2025 to the opposite party. However, requisites has not been filed by the petitioner. By the last opportunity, 1 week time is granted to the petitioner to file a requisite to serve opposite party number 2. Please the matter up. Yes. 30.
In item 30, your lordship may allow me to make my submission on behalf of Mr. Mohanty.
Yes.
But there is a delay in filing CMAPL number 153 of 2000.
How much delay?
8 years.
8 days.
8 years.
8 years.
8 years.
Now you explain. What have you said in?
The conducting counsel, Mr. Pratar Mishra, died in 2012. And the matter was listed before this Hon'Ble court and it was disposed of.
In 2016. 2016 it was dismissed in default. And he died in 2012.
2012.
And then is it a sufficient cause?
No, that is not.
Then dismissed on the ground of.
There was no communication between the council and the.
See, 2012 he dies. You file a case and forget it, and you start blaming the lawyer. It is your responsibility also.
Yes.
Then, see, 2016 your petition is disposed of, dismissed, and 2024 your application.
2024, when it was inquired about the status of the writ petition, it was ascertained that the conducting counsel died in 2012. Thereafter, the application was filed along with the application for condonation of death.
I don't think I can help you.
But it may kindly consider it.
No, kindly is not the issue. Issue is I have tried. 98 you file the petition, a writ petition, and in 2024 you come and inquire. 1994, 98 you filed, and 24. How many years? You just tell me.
26.
After 1 January, 26 years. Thereafter you come and ask your lawyer, what has happened to my case? By that time, 2012, your lawyer has died. And that is the call.
That is the only difficulty.
No. That's I can't entertain this kind of petitions. How can I entertain? I have to write something. I have to justify. 1998, a writ petition was filed. 2016, it is dismissed. Your lawyer died in 2012. In 2024, you come and ask your lawyer who has died in 2012. And you file an application. Restore. Sufficient cause means every day's delay has to explain. 8 years. 98 writ petition, I'll restore it. How can I restore it like that? Right now, the present petition suffers a delay of about 8 years. Petitioner is seeking restoration of the writ petition number, OJC number 9436 of 1998, which was dismissed for non-prosecution on 11/8/2006. The only ground urged in the application for condonation of delay in filing the restoration application is that in the year 2012, the conducting lawyer, Mr. Pratap Mishra, has expired. Therefore, there was no communication from his side to the petitioner. It is surprising to, nothing is coming forth on the record to suggest that any effort has been made by the petitioner to ascertain the fate of the case was filed in 1998. Rather, on the contrary, the petitioner submits that in the year 2020-24, when he inquired from the council, from the office of the council for his council, he came to know that the council has already expired in 2012, and the petition has been dismissed for non-prosecution on 11/8/2016. It is surprising that the writ petition filed by the petitioner in 1998, no diligence is shown by him. Rather, only after expiry of 98/2/24, expiry of so many years, he started inquiring about the fate of the case. Therefore, according to me, there is no, according to this court, there is no sufficient cause shown by the petitioner to explain the delay in filing the application for restoration. Hence, the IA number 195 of 2024 is dismissed as a consequence of the CMP is also dismissed. Yes, next.
You'll also make that liberty the cause of action otherwise face petition maybe.
The petitioner at this stage, petitioner submits that he may be given liberty to file a fresh petition if cause of action survives. Cause of action survives. If the law permits so, he may do so. Yes.
31.
Sorry. Speak little louder.
I have filed an withdrawal memo for withdrawal of IN number 519 of 24.
Flag N.
Flag N.
Withdrawal memo.
Yes, your lordship.
Flag?
Flag N.
Flag N. M. Yes, what do you say?
My lord, I have filed another IA 133, 130.
You are only filing IS. How many? 1, 2, 3, 4, A to Z, M tak aa gaye.
There are several IS, your lordship.
But what are which I is the surviving I?
IA number 591 of 2024. Previously, I have filed this IA.
Which one you are pressing now?
I am placing 591 of 2024. 591 of 2024.
591. What is this?
This is for the condonation of delay to restoration of the second appeal.
I'll just simply issue notice.
Your lordship, the notice will issue on 113 of 2025.
No, what is the service position?
This is the fresh IA which I have filed for condonation of delay. Previous IA I am withdrawing my lord. Because some paragraphs I am missing out.
Which was the previous one?
Previous one is IA 591 of 2025.
5?
591.
591.
Yes, sir.
Learned Counsel for the petitioner seeks to withdraw the IA number 591 2024 as he has filed a fresh IA with all particulars being IA number
113 of 2025.
113 of
2025.
2025. IA number 591 2024 stands dismissed as withdraw. Issue notice on the fresh IA. What is that number?
113 of 2025.
Yes.
Yes.
32.
I'm on behalf of the Honorable Senapati. I prefer time. I prefer time, sir.
Sorry?
I prefer time.
Modification order. Urgent. On the request of Learned Counsel for the petitioners. No. Urgent to yes. 34. What happened? 33. Withdraw.
33 urgent. 30
Withdraw. It will be happy. Opposing.
No, but rather I was interested to settle.
But he is withdraw.
I came purposefully for a settlement because concerning the person concerned. But now that we withdraw.
Yes.
I am not more real.
34.
My lord, Mr. Dipti Ranjan Mahapatra power file is power tasking now better tomorrow.
Sorry, I couldn't follow you. What do you want?
My lord,
Dear
Mahapatra, consent as power file person, power
for petitioner.
Want to change the advocate.
Acha, Counsel for the petitioner submits that the legal counsel has been discharged and wants to file workout now. Says let him do so within a week. Leave the matter after 3 weeks. Yes. 35.
In the Vansis case, I am the accused. I have, after cross-examination of the opposite party, I filed a petition under section 243 of CRPC and 73 of Evidence Act. After hearing of both sides.
Why there so many hearing taken place here?
Mother?
So many hearing.
The other case, I paid now the 3290 of 16. That is the main case.
No,
3290 of 16, the last case.
3290.
Yes, that is the first case and the main case. The petitioner is the accused in the Watson's case, in the check bounce case. After cross-examination of opposite party, the petitioner filed a petition under section 243 of CRPC and 73 of the Evidence Act to allow the petitioner to for handed export of the check because he had not filled out the check. In the cross-examination, the opposite party has said that jodi check export paku jaye more kichhi objection nahi. He has no objection in that petition.
Where is it?
It is page 15. The cross-examination last parak, page 15, annexure 2.
Yes. 15, huh?
ये check जदि handwriting expert पक्कू दिया जाए मोर किसी objection नहीं. Tough.
15, huh? 15, page 15.
आगे.
16.
You'll also
That's
page
16.
15 of CRLMC 3290.
No. 3290, page 16. That's
Yes.
page 16. Yes. Check, not 15.
It top.
Not 15, 16. That's 16.
Sorry.
एक चेक यदि हैंडराइटिंग एक्सपर्ट को दिया जाए
मोर किसी objection
नहीं. I have no objection. Yes, you are a picture.
And the law court below has rejected.
Now you have said that let it go.
No, Your Lordship. They are praying that the check should go to a handwriting expert. After
What
that,
if on the ground that in the cross examination you have
they have not taken this ground anywhere. From the very beginning, they have not disputed whatever it is.
Is he covered by Oriental?
Yes, Your Lordship.
Is he covered by Oriental or not? Tell me. Simple.
Yes, Your Lordship.
Huh?
It is covered by Oriental and
So-
it should not be sent to the handwriting expert.
If is
Once it is an admitted fact,
Oriental is
we are not
the
disputing.
landmark judgment.
This is the
Recently, Your Lordship, Beer Singh has
Oriental
also
is
covered it.
landmark judgment.
And when he has admitted, he is not denied.
Admitted in the cross
In the
examination.
cross examination, he has admitted, he has no objection.
Your Lordship, that is why it is not necessary to send it to the handwriting expert, Your Lordship. And moreover, this honorable court had directed the case to be disposed of within 4 months, Your Lordship.
On that ground,
But
he
because
has
of this
rejected.
tactics of the opposite party, the case is lingering.
Because the court below has rejected.
How will you get over this, Oriental? Once, see, in reply to the 130 notice, have you said, have you doubted?
I have not
See,
received.
your signature is appearing in the check.
Yes, Your Lordship.
Then you are gone.
The signature is
Then 139 operates and.
There is a for a presumption, because I have not filled up the check, I have simply handed over the
Filling
check.
up is not meant, signature.
Signature I have not written, but I have not filled up the check.
Show me where we have disputed the signature. Then where is show me that you have disputed?
No, I have not disputed the signature. I have disputed that I have not filled up the check.
It's not necessary. That is what Oriental says.
But when the
You think that when Ambani gives a check,
Ambani is
he will fill it up.
Ambani is
His staff will fill it up.
but Ambani is a big person. It is a small.
Everybody, you may be Ambani. You are appearing.
No, I am not Ambani, but I am a small person, my lord.
See, signature is important. Who see generally what
Signature, my signature I have not.
accountant, whoever there in the office, they fill it up, and the check holder signs it.
Check holder signed this.
So therefore, Oriental says if the check is disputed, the signature appearing in the check is disputed, then it can be sent.
But that
is
case,
Oriental.
and that the Oriental case and this case is totally different, my lord. Because he has a filled up. That is a check. I have not denied. I have not.
Show me. That's what I'm asking you. Where is your reply to the 130?
I have not filed any reply. I have not received notice.
So then, where is the
cases in
where is the
between
complaint
tried.
copy? Where is the complaint copy?
Your Lordship, there is a mediation report also that has been tagged along. This matter had been
Yeah,
sent to mediation.
Mediation failed.
Yes, Your Lordship. It's an
Where is
amount.
the copy of complaint? You show me. Where is the complaint copy? Complaint copy.
I have not.
Show me that there your right will be ascertained.
Come 2 weeks after, I will submit that.
Your Lordship, the copy of Akshita 7.
There are more pits.
हाँ, अपन को petition में अच्छी सही टाइप का sir.
1/6 less.
Sir, Your Lordship, even if looks into the evidence on affidavit, that is the same as the complaint.
You are relying upon Circular Begum BV.
Yes.
It's 2011. Just see 2022 Oriental is against you. What to do? Directly against you.
No, I will come. Submit. We will come 2 weeks after. I will submit.
I'll pass it over. Just see it. Directly.
No, I have seen the judgment. I have
directly against you.
I have also submitted.
Once you say that your signature appears in the check, then it need not. What I'll do is evidence exam. Evidence. छोटे-छोटे की लगते नहीं आते. Just see 73. I'll record 73 and allow you. Let the trial court do 73. Just see 73. Section 73. It will be a balancing act for both of you. Read it loudly. Let the magistrate compare it.
Yes.
Your Lordship, but that would be virtually allowing their prayer only.
No.
That is the reason the
See,
magistrate
73 says that magistrate can very well ask for his signature and have a comparison
Your
and take a call.
That is what has been done, Your Lordship. If Your Lordship looks into the rejection order by the magistrate, why their prayer for handwriting expert has been denied, Your Lordship.
That is, even if I don't pass an order, it is open for the trial court to employ 73.
The court below only rejected because this one directed to dispose of the case within 4 months.
Okay, 73.
On that ground, they rejected.
73. Right up.
Your Lordship, however, there is a rider that earlier order Charimaswitri Saria ko thila. So Your Lordship may.
I will not say anything on that. While the final disposal, 73
Yes, Your Lordship.
pages, you
No,
And what
unnecessary
about
urgent.
the first matter?
Otherwise infructuous.
Infructuous.
Is disposal, they are all infructuous.
Acha, acha. Second matter is order of you the hero. They do 73. Zero. File value what's it? Hard to be. Okay. 73 should be. I'll pass it.
Much appreciated.
Infructuous. First one is infructuous in view of those. I'll just come over.
Personal. 35 sir. 36
Party. On 29/4/2024, notice was issued to opposite party. Service देखो. They might have participated in the.
They have-
here
they have
they have to
appeared.
come.
They have appeared there, madam.
Let us see.
And mediation report is there,
Service.
madam.
1 minute. Notice be served on the opposite party number 2 through IIC, Soro. Mr. Vishwal, notice has been served. Opposite party number 2.
Mediation successful, madam.
I know mediation, but see, he has to come and tell me that mediation is successful. Next party can't be on. No. Have you taken the step?
We have.
Then also for the petition service that by order 29/4/2024. That was mediation. Very Right. I'd be. In CRMC number 3248 of 2023, directed the Chief Judicial Magistrate Baleshwar to conclude the city case number 2507 of 2012 within a period of 6 months. 6 months. The Chief Judicial Magistrate Baleshwar has addressed a letter to the registry of this court dated 13/1/2020-25, seeking an extension of the time for another 3 months for disposal of the CT case. For the reasons stated in the letter dated 13/1/2020-25, request made by Learned CJM Paleswari is accepted, and further period of 3 months is granted. 4 months. Further period of 4 months is granted to the Learned CJM also to conclude the trial in CT case number 2507 of 2020. Yes.
37.
Item 37, the date of, in order sheet, the date of order has been typed as 7th of February instead of 7th of March, Your Lordship.
7th of
February instead of 7th of March.
which order?
Dated 7th of March, 2025.
Which order you are seeking correction? March of the order. 7/2/2025 order is 7/3 actually.
7/2/2025. Order is to be corrected as 7/3.
3/20. Okay.
38.
You got correct. 7/2.
Petitioner.
Yes.
Now, defendant 2 and 3 are the petitioners in a pending final legal proceeding. Here, the OP number 1 is stranger purchaser. He filed a suit for partition.
Yes.
Copy of the plaintiff order annexed to page 10.
Who is appearing for the other side?
Yes, I am appearing for opposite party.
Yes.
1.
Come this side. Yes. Yes.
Copy of the plaintiff is at annexed to page 10.
Yes.
Here, the Manoranjan Pradhan, the present OP number 1 as plaintiff.
Let us come to the impugn order. How are you agreed?
Okay, sir. And then I'm.
Yes.
What happened? In the partition suit, the defendant 2 and 3 have filed written statement, and at page 21, paragraph 8 of my written statement.
Yes.
We have specifically contended that the आमे विवादी पक्ष टाइट यूनिटी पोजिशन नथिला नै विरोधी संपत्ति आमे विभाजन पैतृक घरवाड़ी संपत्ति एकांश अटे तहिरे बादींकर तिळाले सत्त अधिकार नै वी हैव ऑलरेडी प्लेडेड इन द फाइनल डिग्री प्रोसीडिंग we filed a petition. Defendant 2 and 3 filed a petition because defendant 1 has sold the land, part of the land in favor of the present opinion 1, which is stranger purchase.
Who are you?
We are defendant 2 and 3.
2 and 3.
Our petition in the pending final legal proceeding is at page 24.
24.
Right.
Okay.
Defendant 2 and 3 filed a petition.
Yes.
Here we pray.
Petition on behalf of defendants. Yes.
Defendant 2 and 3.
Yes.
1 is not contesting, he has already sold.
But it is written defendants.
Defendants.
Yeah, anyway, there are 2 defendants. Okay.
2 and 3.
Yes.
Page 26.
26.
In the above circumstance, it is prayed that your honor may graciously please to direct the plaintiff to execute a sale deed in respect of half share of land of the plaintiff, which he has purchased by exhibit 7 and 8 from defendant 1. And section for person act relief time again. Then kindly come to the prayer. Impugn order mail.
Yes, no, you are asking for the execution of sale deed in respect of
section for person act or relief time again.
Yes. On the valuation.
The Law and Trial Court kindly come to directly page 31.
31
of the order.
Yes.
Last paragraph, only one paragraph finding is given.
Yes.
Peruse the petition, its objection, and the entire case record along with the submission of Law and Counsel. On perusal which time it appears that suit has been declared preliminary declaring half share of the plaintiff in the stolen suit land. The defendants have filed the WS and contested the suit. For the defendant neither raised any counterclaim nor pleaded in that WS. It is error made. We have already pleaded. Regarding declaration of suit land as home and hosted, any other agreement, for no issue has been framed in this regard in the suit.
So when the suit has been declared, prior to the penalty, at this stage, they really, this is also a wrong proposition. Till disposal of the final degree proceeding, section 4 can be invoked. That is case law. I will cite now Supreme Court judgment and this honorable court judgment. Yes. At this stage, the relief claimed by defendant is not at all maintained. A petition agen ठीक रे विचार है नहीं आउट रिमांड ले यही पॉइंट ओवर व्हाट यू से आउट रिमांड ले यही जो पॉइंट हम कहू छी तापर से यस सर तळ कोड किछ तापर देले नहीं जे हम ऑलरेडी प्रीडेड वी हैव ऑलरेडी प्रीडेड इन आवर डब्ल्यूएस एंड से पहले ये जो फाइनल डिग्री पेंडिंग समय रेज करि पाते सेटा ही भूल यस आर यू रेडी यस मिलर यस
Milord, first is the opposite partner one respectfully submits that the suit property related to plot number 612, 613 and 617 under Khata number 57 of
Yes.
Mudas Hon'Ble in consultation of ROR published on.
I think it needs a little hearing. I'll pass it over. I'll just go through the entire list thereafter I hear you. It needs little hearing. Okay. Just pass over. Just pass over. Okay.
39.
Yes, sir. I'll just run through the list, then I'll tag it. Yes.
Well, 39, I am for the appellant. I'm for the petitioner. My friend Mr. Rautra is also along with me, supports.
Yes.
The case is that the son of the petitioners who was working for JK Paper Mills succumbed to an accident and died. His service benefits were given to the bank. It was credited. Opposite part number 1, Axis Bank. Then the wife of the petitioner, the wife of the deceased, and the children left to the parents' house, their parents' house. There, all of them have committed suicide. Both the wife of the deceased, children, and also her mother, the mother-in-law of the deceased, all have committed suicide. Mother-in-law of the deceased was the nominee in respect of the bank accounts. So I filed an application for
the benefit.
For the benefit.
To be transferred to you.
For the benefit.
Okay.
And LIC have also credited the amount in the bank, same bank. They had no issues. In respect of one more policy, they are yet to release. That's one. There, what has happened? To the bank, the father of the nominee had sent a letter to find out what is the position of the account and what is to be done.
The bank only will give it to the nominee or the natural successor.
Nominee's father.
Yes.
Bank will have to give it to the nominee, but nominee died, depositor died. So Hindus, under the Hindu Succession Act, whoever is entitled is to get it. And now the parents of the deceased are only the legal heirs, none else. Nominee cannot, the father of the nominee or relations of nominee cannot be heirs. That is all the simple point.
But all of them have died.
Died. So the nominee's father had written a letter to find out from the bank as to what is the position.
Now bank is withholding.
Bank says that because a letter has come, we cannot give it. Get a certificate, succession certificate. We have applied for succession certificate. And hearing was over. Hearing was over, evidences were reduced. But at that stage, when the trial court says, since a letter was given by somebody claiming about the inquiring about the accounts, he should be implicated as party. He has no way, by no semblance of right, he is to be implicated because he is the father of the nominee.
In the succession proceeding.
In the succession proceedings. So against that order, I have come.
Yes, sir. In the succession proceeding, how are you?
In the succession proceedings, yes.
May I understood it? In succession certificate, how are you? Succession proceeding. How are you?
He is with me.
Now, who is there then? Who is there?
I am from the LIC.
In the LIC bank, who is for bank?
Axis Bank.
Objection, man. Only thing out, say the person जो जेकी नॉमिनी से कहूची फादर
Let him do whatever, but he is a necessary party in a succession proceeding. The question is that.
Section 15 देखो
As simple as that.
clear
Let
successor में आसीबो ना नॉमिनी
the succession certificate be, the succession petition be decided, and in accordance with the law, the bank will take.
That's right.
As simple. Where is the bank?
That's right.
Who is appearing for bank?
In the succession proceedings, because the impugned order has been passed, I had to come here.
Has he moved application before the?
Nobody. Rather, even
Bank has.
Order 1 rule 10 application, let him move application and let the court decide.
That's
whether it's
right.
necessary, proper party, whatever.
Other the pure question of law which comes to my mind, I was asking my own friend. It is application of section 272. There is a provision under the Indian Succession Act that objection has to be invited. Within a certain time, as per the requirement of it.
Let him file objection if you want.
Objection has not been filed.
Oh, that's what I'm
That's
saying.
right. Nobody-
I put it in that way. Order 1 rule 10 application after can be moved.
Even nobody has
Is not
come
moved
to
application.
Yes.
And if he's agreed, let him move application. Let it be dealt with in accordance with the law.
Now the judge.
272 proceeding.
Quite
It's
correct.
272 proceeding, as simple as that.
Yes, sir. That is good.
Where is the bank guy? Bank is the only contesting.
Bank
Bank ର
Bank control.
It's right.
It's because they have got a letter, they have shown it to the court. That's all.
I'll simply direct the succession court to decide the succession application in accordance with law.
But without including that person, because now the impugned order is that so what the order on rule 10 to allow that person to be imputed as party. And that too after
It is open for him to file objection.
That is right, but he
It's
can.
272 proceeding, any objection come.
That period is over. That period
But
is
let him file. Let him file objection. It will be.
Take advantage of that. Now the person.
I will just give limited time for him to file objection, and if the objection is filed, let it be dealt with in accordance.
Sir, he's not a party. The person, if the lordship will hold, because on 227 lordship can also come to a conclusion. Section 50. He may say that we the preferential here.
Legally.
So legally here.
That has to be decided by the court.
Sir, the question before lordship is whether the case. Sir, देखो, सीट आजे देखी दो.
Hindu section.
Sir, देखो section 15 टा. ठीक के सत्ती.
No, 15 I know, but I just want 272 Hindu section.
372.
Scope of the
372.
370.
Yes. Indian section.
Indian section.
372, 373.
What is the scope?
Application
Objection is to be invited from
373. The city of application, general publication. That has been done. That period is over. Long since.
Yes, nobody has objected.
Nobody has objected. How the court can overlook to this provision and can say at the time of delivering judgment, the court with the argument, that too on the basis of the letter.
Letter given to the bank, not to the court also. That's the problem.
That's also long before.
Bank. No reason, nothing. You also look to the order.
Indian section.
Indian. Yes, sir.
So bad rokho yaar.
देखो कि 78 वर्ष हेलानी जी पिटिशन टकराव केही नाथि वर्तमान ही इज कैंसर पेशेंट आपकी वाइफ इज कैंसर पेशेंट टू इज कैंसर पेशेंट 78 इयर्स होचे हस्बैंड दे आर द पिटिशन विल कलेक्शन
How will you get over 2?
Sir, 373
2.
Yes.
A.
That you're long over.
No, to serve to be served on any person.
Sir, any person.
To whom you go.
That question, that
time is over.
Time is over long since. That time is over.
Show me the impugn order.
Impugn order starts at page 30, 29.
Yes.
30.
Yes.
30.
33.
At
page 32, your lordship find
that letter has been only quoted.
Yes, that letter has been quoted on perusal of exhibit D.
32.
You start.
Sorry, A.V. Raman Rao, so and so.
32.
Why it is letter dated issued the following content to branch manager. I had already submitted the death certificate of so and so and her 2 sons. Siddharth and Saira, and nominee late so and so. And family member certificate of myself issued by the Tahsildar Parvatipuram so and so. In the above matter, I have not received any communication from your side. My lawyer insisting on written reply. So I request you to please send me in writing. He has sent a letter saying that so and so died. I want to be discussed.
Next page.
Since the lawyer is insisting, then next page, in spite of the fact that the petitioner claims that K.V. Ramana has not a necessary party, as this is a case for issuance of succession certificate.
Who is appearing for K.V. Ramana?
That is the father of the nominee.
No, who is appearing here?
He is Mr. Janna, Mr. R.C. Janna.
Call him.
Okay, nobody is there. Nobody is also appearing.
He is a necessary party because
no, that he will...
and the court finds that he may not be necessary party, but he has to be heard. That's what he says. Oh, forget about the bank. Where is Mr. Janna?
Mr. R.C. Janna.
Possibly is appealing for the Axis Bank. Nobody is appealing for the
No. Open
bank,
number 3.
Bank is not interested.
No.
Bank.
Open number 3 R.C.
Because only respondent number 3.
No.
Who is appearing for respondent number 3?
From R.C. Janna, but he is not appearing. R.C. Janna.
Just see. He is to be heard.
RC Janna MR Party.
RC Janna MR Party.
This is our entire case.
But I understood the case, but the problem is
yes.
Behind the page on Saleh, issue court notice to Mr. Janna. What is the practice here? Because I started issuing court notice, there are some objections.
Somebody has appeared and he presented some license
sent to him.
No, court, I can issue court notice to Mr. Janna to appear. Because I issued court notice to couple of lawyers. There was an objection from bar. You can't issue notice to the lawyer.
No, nothing like that.
Nothing like that.
There was objection.
A notice can be given.
If the matters are coming after 20 years, 30 years, if the notice is not sent to the lawyer, how will they know?
That's
when I issued notice, there was objection.
You also know that a court list once it is published and circulated, that is a notice.
But practical problem is you don't keep track of it.
All at a sudden the matter had.
I'll just issue court notice if none appears for opposite party number 3. Matter partly heard. The presence of the opposite party number 3, who is contesting respondent is necessary in this case, Mr. R.C. Janna and MN Party has already filed Gokalaknama on behalf of respondent 3. Let the court notice be served to the learned counsel, intimating the next date appearing. Intimating him the next date appearing. Give a date and put it after
Monday or Tuesday.
Service period.
No, may I suggest one thing?
Yes.
Since your worship is also trying, so in addition to that, let the petitioner also can attempt to give a certain copy.
Who is you are briefing counsel, sir?
That's it.
Who is your briefing counsel?
Junior.
Briefing counsel.
BK Mahant.
The petitioner has also undertaken and is also at liberty.
Yes,
sir. Copy of this order, copy of today's order.
Yes.
On Mr. Janna. Lease the matter on
Monday, Tuesday.
Tuesday, Wednesday could be there. Okay. Yeah.
Okay.
It can be disposed of.
It can be disposed. His presence is required because he must say that.
Otherwise, unnecessary.
Right. Once it will limit the act, it will unnecessary.
Why don't you 30 lakh rupees? Why don't you pay something to him? I can send it to mediation if you want to pay. I'll send it. He must be having little hope. He may get something.
Like in comment, sir.
Yes.
Good.
Yes.
41.
May please, your lordship.
Yes.
41, may your lordship, the last order, your lordship, it kindly peruse. There was a little confusion.
Which order?
Last order, I think the government council was supposed to come up with an instruction regarding the status because.
Yes.
Now the status, I have received it on 29/11/24. Received it.
कौन instruction अच्छी कौन है जी?
During investigation, reported during the investigation, the accused Ram Shankar Singh and Ravi Kumar Sharma are absconded after registration of the case and yet to be arrested in this case. There is the case record and it is ascertained that the IO has seized one seizure list of old Tata truck bearing number such and such from one Tapan Kumar Das, SI Police, Baranagar, ES, Barakpur, Functional of 24 Pravana, West Bengal. IO has received the order from the Honorable Resident Sambepur, had letter dated circumstances for release of the seized truck bearing registration number in favor of Ram.
Let us understand what are you seeking?
No, this is not an instruction because they say the petitioner is absconding. The petitioner has been released by anticipated bail was filed before this honorable court.
Yes.
On 9/12/2016, he has been released by bail, released on bail by the lower court, my lord.
What are you seeking in this petition?
I've sought for. Yes, yes.
No, Ravi
19/12/16.
Ravi Kumar Sharma.
Ravi Kumar Sharma. Yes.
Ravi Kumar Sharma.
This is the order of the honorable third learned court bill. He has been released on bail. So say instruction ta theek nahi. This instruction, the IC which is given that.
Last time also this instruction appears.
Yes, say instruction ta thila.
You read it out.
Then I have to get.
He's on bail already.
What instruction? Yes, based on.
How are you saying it absconding? That must be the prior to the bail.
So I am.
Charge sheet jab file atla se tu abscond dekhaitla 2014 re.
The latest instruction. This is also there. He receiving.
See, this matter is what are you seeking in this case?
But quashing of criminal proceeding because these two brothers they have been implicated only on the basis of confessional statement of the co-accused, and the only liability is receiver of stolen property.
Stolen property.
In cases property has been seized.
Can you pass? The evidence is there.
Evidence also because that evidence also is come to the confession of the co-accused only.
Where's the trial?
No investigation, no seizure, nothing.
Nothing is seized.
No, nothing has been seized from them.
Except the co-accused
statement. Yes, except co-accused, nothing else.
I have to get.
You simply see if there is nothing else. Then why should they suffer?
After bail, yes, I have to instruct. 2 weeks time.
311 there.
311/12.
Then there should be some recovery.
379, no recovery at all.
379 and all principal accused, let them face. That's not the issue. Issue is from her client. What is recovered? 379 accused might have said that I theft it and sold it to XYZ. But unless you link it by recovery or something of that sort, nothing is there.
That is clearly stated.
Seeks one more opportunity to get instruction from the IAC in the present matter regarding the complicity of Mr. Mahanti. Petitioner submits that except to the confessional statement of co-accused, no material has been collected by the petitioner against the no material has been collected by the agency against the petitioner. Let the state council obtain instruction without fail by next date of hearing. In the meantime, the interim order passed at yes, continue. Yes. 42.
Interim order to oblige.
May I please, your lordship.
In item 42, your lordship may see the noting, the LCR has not yet been received.
LCR is not traceable, they say.
Oh, let them be given opportunity. Where will the LCR go?
the change of building and all that, possibly that has caused this.
Not received in this regard. Scan copy is also not there, yes.
Change wala sir, building, old building or new building, that could be the problem.
Update also.
Yes.
EBS.
Yes, yes, Mr. Ponda, what do you say?
But unless the LCR is received, your lordship will not be able to go through the evidence. It is based on a complaint petition.
There is no evidence as such 321 was allowed. Thereafter he has
Then,
come.
Registry put what is the solution? NCR has to be there. I don't know.
Would a reminder te jao?
The report suggests the NCR was called for by the order dated. By the order dated. By the order dated 13/11/2024. The report suggests that the NCR is the record, case record is not traced out. Scan copy of LCR also cannot be submitted before this court as the records are not traced out. No. The registry is to registry to locate this case record and place the scan copy of the NCR by next date appearing. Please give a control entry model. Yes.
Grateful with that.
What time they will.
43 interim order may continue.
Entry order will continue.
Lordship, I am appearing in two other matters are there in your board, Lordship's board. 48 and 52. 48 I am appearing today in 53. Huh? 53. May I seek for today's accommodation, Lordship. Interim board the cases.
You be there. You tell me.
In both the cases, interim order.
You tell me. You tell me. When it comes, you tell me. Yes. 43.
43. Item 43 Millard, arising out of NI Act Millers, but order passed under section 143A is under challenge. That interim compensation. That your lordship, this honorable director for mediation that has failed, my lord. In the meantime, what happened, my lord, that your lordship, PP to some other final hearing matter, I will place some judgments because there is no other judgment where the discretion can be applied in a
everybody knows that.
No. Here is a case. Yes, here is a case. No, not lingering. Here is a case, my lord. The money is admittedly paid for purchase of a land by registered sale deed. That has been in 2016. Now the very same money is wanted to be refunded, even though land is with them and registered. There is no dispute over that. And so far, they have taken a stand since government has acquired the land and a part of land is by approach road. They have filed a separate suit against the government and the injunction has been granted in their favor. Another 1cc case is also filed against this petitioner in Puri district, Millard. These are the things. Whether my respectful submission will be in a present fact of the case, your lordship will say whether there can be any compensation.
Interim compensation.
Yes, there are other decisions I have gone through, but my respectful submission, this is not at all a fit case where interim compensation because admitted is the admitted case of the complainant. That money was granted.
You are appearing for the.
Yes, my senior is appearing.
Pay 10%.
Well, that is the order. That is the 10%.
10%. Let him.
10% is under challenge, Lord. My respectful submission is under the law.
In case of 20%,
I will place the judgment. I will place the judgment. Subject has been
was the judgment which you are going to show. I'll tell you what is the judgment. He says that it's not mandatory. Direct. That's not the only judgment.
I am not today.
If an interim compensation stays,
yes,
if the 482 court start entertaining this, I just gave an opportunity to settle. If you don't settle, then don't pay.
We are ready.
That's the only thing.
We are ready to pay. The difficulty is we are even as per the settlement, we are trying to pay back the entire money. But the fact remains they have to return back the property, Lord. Unless that is their admitted case. Unless
return back the property sale deed has not been executed. What have you given them?
By registered deed in 2016, my lord. That is the admitted case here, my lord. That is I mean difficulty. Unless the land is returned, how can I am not in a position to pay that?
File a suit.
That is their case. That is their case. The government has acquired the land. They are with the valid title. There is no dispute over. Any third party dispute not there. Now they have filed a and suit when the land is with them. So even if we tried in the mediation center that you return the property within 6 months, we will pay entire due without any difficulty, or even that was not accepted by the opposition. That is the difficulty. So your lordship may grant.
Yes, Mr.
That is
Tripathi, what
difficulty.
At least next week as
Two chapter, I will cite some judgments.
No, if that is the only dispute, if you give back the money.
Yes, we are ready and willing, but they are not getting some time because they are.
My simple prayer is, when the mediation fails, it should go to the original court, they will decide it.
That's a different story. We will take it up.
Because for that reason it is legal.
No, I have not passed the stay. Is there any stay?
No stay is also
There is
there.
no stay. You
So
can
my
proceed.
responsible submission is yes. Lordship may 2 weeks
There is
time.
no stay.
We will finally dispose of. Lordship may dispose of the matter by. We will cite some judgments.
In the absence of any stay, what is the problem?
Whether it is an appropriate case to file, if this my responsible submission, if there is a discretion that has been defined, that should be judiciously, and even zero without discretion. This is not an appropriate case.
The court has asked you to deposit 10%.
10%, my lord. My responsible submission, I will cite some judgments. I am relying on those. This is absolutely a different fact altogether. I am not in, and they have taken the stay order from the government. They have engrossed. They have filed even the land acquisition. They have claimed land acquisition. So where we will go, my lord? They are praying land acquisition.
The remedies are somewhere else.
That I
In
yes,
138,
your lordship,
you want everything.
I am cautious of your lordship's behavior.
You have to resort to some
I
other
am
remedy.
difficult. Even we tried to settle the matter.
That is the reason I sent it to mediation.
Let them reasonable time. Your lordship may direct reasonable time return of.
He has to agree. I can't force him.
Yes. That is there. We are making a submission.
If he agrees,
if
then
6 months
I'll
time will given with return of.
Why 6 months? Why 6 months? You have taken the money. Give it immediately. They'll give it. Why 6 months?
I instruct them. Let
come with the check amount. That is 15 lakhs 45.
I used to subject to both since mediation. I will again ask your lordship's view.
15 lakhs 45,000 check you bring. I'll ask them to do it immediately. Finish.
But that is also I will your lordship to
You have taken the money now. You want 6 months, 4 months, 3 months. What is this?
Difficulty is the
And
land.
who will
Once
give the
the
interest
land
on this?
sold, my lord.
See, who will give interest on this?
But they have already, that is 8 lakhs, some thousand is the amount. They have already claimed.
You come with the check amount, I'll tell them
They have
to
claimed.
enter into everything is finished. Come with the check amount. Forget about
I
the
have
6 months.
I have to sell it and get the money. That is, I'll try my best to convince my client also. That is your lordship may see this.
There is no stay. I
No
am not
stay,
telling
lordship
you.
may keep it
Simply
23rd or
at the request
30th.
of client counsel.
Weeks after, my lord.
Yes.
20th or 30th. 23rd.
He'll give a date. He'll give a date. Wait.
My
He'll give a date. Yes. 44. Yes. $44. Nobody's there. First. 45. Yes,
My lord, in this case, my submission regarding 4 documents. No. Annexor 2, documentary evidence. Annexor 2, Annexor 3,
What are
Annexor
you-
5,
what are you-
Annexor 8.
What are you
Sir,
seeking?
I come to one by one. Annexor
No,
5.
what are you seeking? First, let us understand.
The concern IIC, airport IIC, Umakanta Pradhan. Now, I brought to the knowledge of the court, he has been transferred to the other police station. Repeated violate the court order as a government servant, repeated violate the court order, Annexor 5, SDGM order, Annexor 5. Annexor 2, the accused number 1 to 4, along with witness.
Are you an advocate?
Advocate. Along with the witness in the presence of ASI conducting officer, in this case, ASI. But when the report submitted the revisional case, the session judge directed the police submit the revisional case. In revisional case, this change the IO and without charge sheet, submit the final report. Final report, Annexor 5, Annexor 2, they give an undertaking. 4 accused and along with 2 witnesses in the presence of IIC, Umakanta Pradhan and ASI Boykutranath Behera. Number 3, after
What
that,
is the dispute?
disputes dispute only the false and final report and violate the court order by the police, not proper investigation, not proper submit the report,
you are the
only
informant.
false and fabrication.
You are the informant.
Informant.
Yes. Yes.
Annexure 8 is the final report. What mention the final report? They mention that only falsehood and fabrication information and misleading to the court.
If you are informant, if it is a final form file, then you would file a protest petition.
My lord,
have you filed a protest petition?
File a protest petition. Already, the honorable court already passed the order. Notice has been issued by the SDC. No notice has been issued because that time the revisional case was proceeding before the session judge. Session judge already called the LCR everything, but wrong order passed. Go to the protest petition before the ADGM file the protest petition. LCR is before you. How the ADGM pass the issue the notice to me? Nothing. This is a wrong order. And dismiss the revisional case.
Don't go see, just see your prayer. What are you seeking?
My prayer is concern, sir.
What happens, you know?
The final report.
Listen to the court. If the doctor will start operating himself,
Doctor?
He will die. Doctor will start operating himself, then he himself will die. Likewise, if a lawyer will conduct his own case, he is bound to spoil the case. You engage a lawyer. If you don't have a lawyer, then I'll request someone who is present here who will assist you so that it will go. See, you have,
my lord, kindly,
you have created a chaos. As a result of which you, at the end of the day, you get nothing.
I pray to court you facts of the case and material evidence available.
No. Your prayer.
Myself or other I engage other advocate, that is not a matter.
For your
the material evidence is available. How the false report was submitted?
That's the problem. The courts have courts are not hearing you because you don't hear to the court.
No, I am not. I am not doing the oral evidence or other circumstance evidence. Not material evidence are available.
Try to appreciate. You will spoil your case. I will request one of the best lawyer here present to assist the court, and he will do it for you. Otherwise, you will spoil. You have already spoiled the case. You have a grievance against all the judges and all. That doesn't happen.
How I'm not spoiled,
see this,
my lord. I'm not
spoiled. Just see the prayer. By reading this prayer,
my prayer part is concerned. Action taken against the police. How is submitted the how we violate the repeated violate the court order.
In the course of if a police after investigation file a closure report, if you are not satisfied, the High Court will take action against the police.
I am not the authority of the police. Police action taken should be action taken by the court.
You may not be satisfied being an informant. There are the procedure is there in the CRPC. You have to go by the procedure.
If police violate the court order, then I am the authority. I am not authority.
Yes.
Police violate the court order.
Do you need
the government servant?
Do you need a lawyer?
Yes, sir.
To be appointed by this court who will assist the court on your behalf. You need not pay anything. But you being a lawyer, I'll request someone who can assess the court. Okay?
As it is said by the honorable.
Yes.
But parts are about to the.
Please help me. And I will request Mr. John Senior Counsel also. He is a lawyer. Please help Mr. Otho. You can please either both of you can do.
I'm from the same chamber.
Very good. Now both the topmost lawyer of this court without me can do it for you. Okay, please go to them. Give the paper. I am putting it on. Let it be on 8. No, not right. No, April. No. 8th of this one. April 8th.
9th or 10th?
9th. Will he be
10th?
Yes, 10th. Okay, 10th.
Yes.
You give the copies.
Yes.
Okay. He tried to find out because he has procedurally things are bungled up, you know.
Fine.
Try to find out how to. Yes.
Okay, clear with them.
58.
Item 56 matter. Compromise matter also different to the land has never gone. He has to come from Barbar. The operator is going to date me.
What are the offenses?
The last occasion you also directed
Hey,
my ordinance.
tell me the offenses. If it is minor offenses. 56, huh?
Yes, offenses 420, 460.
420. Okay, 420. 420. Keep it on.
Directed me to see was once appeared before Lordship's matter.
130B. How many accused are there?
3 accused persons.
All the settlement through
Yes,
all the accused?
Yes, my lord. Settlement is there, my lord, but
Fix
per
it,
plan.
fix it. Then let it be on when make a quarter 15th? 15th. 15th. Okay.
Item 47, both of us are there with referral items. That matter here mediation which was.
He's seeking adjournment. Are you opposing?
No.
Adjournment. Oh, 15th or 16th? 16th. 1 minute, let me. Entry want to continue. 16th. Yes. Yes, sir.
My lord.
Okay, on behalf of Mr. Tau, A.K. Sau.
My lord.
Council.
My lord, item 52. Well, item 53, my lord.
Entry want to.
Also, item 46.
My lord,
46, I have objection.
item 53, my lord.
40?
I have objection for adjournment.
Which one? 46?
46.
Okay.
May hear it.
Item 53, my lord.
Item 50 is
one after only. Okay. He's saying something else. Yes.
Item 53, my lord.
53.
My lord.
Yes. Mr.
Sarang,
He has requested. Who is appearing for the other side?
Other side state and the
Private counsel also there, my lord.
Where is he?
Yes, there.
So wait then, wait. I'll accommodate you
My
because
lord.
Mr. Sarangi has said, but let him come.
My lord, item number 52, my lord. Senior is out of station, my lord.
Is there any stay order?
No, my lord.
Okay, simply on the request of Land Council for the petitioner.
52.
Das Mahapatra, Raghunath Das Mahapatra.
My lord, item 50, when we sought adjournment for
50 also, is there any stay?
no stay.
No stay. You are for? You are for?
the petition.
Yes.
The Madam is appealing for the informant.
No, yes, opposite man not to.
Council for the informant seeks an adjournment. Entry order there?
No. The question on the question of compromise.
Item 40, yes.
Filing the memo.
Defects are for Rahul.
And
The killer line to the Baba.
I'll take it up.
Yes, I am opposite department number 2, my lord.
What do you want?
Let it go. Let's
48, huh? Joint request.
That's the interview part.
Interview for joint request, please.
Which by untrained was 4G.
48, yes. 46.
Yes. After
Okay. Joint request, 1 with the upfront. 46. Joint request, 1 with the upfront.
Any specific date?
Give a date. Let's just a date within a week or so. Yes. Yes. Any mention? Entry order to continue. Yes. Any mention? Here, I have already adjourned. Okay. Thank you. Thank you.
Your lordship, it's a CRLA matter. I am it was list.
Mentioning it to 10:30. You are here. I told you. Yes.
Your lordship, it is a CRLA matter and it was listed before this honorable court on 17th March
but it did not reach, so may kindly be taken off. Yeah.
Yes.
So item 5.
By
Out of 4, my lord, I examined the evidence, 1, 10 and 3. 3, of course, some questions are, 2 may not be relevant, 1, 3 and 10, your lordship.
1,
3 and 10.
Yes.
But 1 is the informant, 10 is the son. And all the questions are irrelevant now. They have already given the opportunity and they have already cross-examined also. All questions, they have relevant questions. These questions are related questions only.
Related.
Only to delay the proceeding. Now, after the completion of 15 witnesses, now he has filed the application for.
Your lordship, can you see the nature of the questions I have put?
Yes.
My lord,
after 2 years.
This is a case. My lord, due to death of 2 hens, the meeting was convened. And under the chairman.
That's not the issue. Why
No,
have
my
you
lord,
not
this is
asked
the background of the case. My lord, why I say, my lord, informant and his son, her son, claims to have seen the occurrence, though they are not present. The PW10, who is the student and is studying at
No, why have you not, according to you, have not asked the question? Why have you not done?
That is because of my lord, latches on the part of my lord.
Then?
He couldn't ask relevant.
Choose one witness.
But your lordship.
Choose one amongst best.
Son is also residing
1 and
at
10, your lordship may confine to 1 and 10.
Son is residing at Bangalore.
Yes, he claims to have seen the occurrence. He was staying there. That is my question.
But no, he has put all the questions.
That's the problem. You have not asked the question. He is resident of Bangalore. Again, it will be, what are the charges? 302.
302.
No, para 4, page 15. Para 4. On perusal of the record, it is found that the informant people 1 has been examined by the prosecution on 24/5/23 and cross-examined by the defense on the same date. The independent witnesses, that is PW 2 and 3, have been examined by the prosecution on 25/5/23 and 26/23 on the same dates. Likewise, the son of the informant, PW 10, has been examined by the prosecution.
And who is staying there in Bangalore?
Son.
PW 10.
But he claims to have, on the relevant day, he was present in the village. He has said.
PW 10.
Yes.
Okay. PW 1 is the informant.
Is the informant.
And what about PW 2 and 3?
2 and 3 are
They were also
laborer. Two villagers. They have also claimed to have seen the occurrence. But
So then why
the
are you
question
insisting
I have seen the questions. But it is not so far as
No,
PW2.
but why are you insisting for 10? Who is in the Bangalore?
No, he's not there now. Because he claims to have seen the occurrence, he is a vital witness.
Equally, 2 and 3 have also claimed to have seen it.
But 2 million, I've seen the occurrence. He has been put. All PW2 has been put. All the questions may not be required to put again. I confine to 1, 10 and 3.
Only one.
One, also with that. They will moderate questions.
Therefore, I am only allowing for one. Right. Petition is by the order dated 27/9/2024, whereby his application
1 and 3 villages,
section 311 CRPC to recall the witnesses, prosecuting witness PW 1, 2, 3, and 10 has been rejected. The trial court, while rejecting the application, inter alia has observed adjournment. Para page 15, para 2 or 3 onwards on perusal of the record. Ending. Okay. The petitioner has placed on record the application under section 311 CRPC, and along with the said application, schedule of the questions proposed to be put to the witnesses have also been enclosed. Perusal of the questionnaires reveals that the questions sought to be put to the question proposed to be put to the witnesses sought to be recalled have already been directly or indirectly have already been put to those witnesses while they were subjected to cross-examination. And the petitioner have also placed on record the deposition of all the witnesses sought to be recalled for cross-examination. Mr. Mishra and counsel for the petitioner submits that the petitioner is facing a grievous offense, namely section 302 IPC. Therefore, the petitioner has the indefensible right to defend himself. The opposite, the PW1 is the informant in the present case, whereas PW10 is the son of the informant, and PW2 and 3 are the villages. Villages and independent witness. Yes. Independent witness. All the witnesses have claimed to have witnessed the incident. Therefore, the questions are framed aiming at creating a doubt regarding their presence. Yes. Regarding their presence. I have perused the questionnaires framed by the petitioner to put to the witnesses, and I also have examined their testimonies. Taking into consideration the document placed in this petition in entirety, I am of the view that the petitioner's application under section 300 CRPC VCB PW1 and a independent witnesses. PW2 you want 3-1.
110. Your Lord, Spain was reading by then.
Then I'll not call because he is in Bangalore. He'll come and
anybody of
2 or 3.
3.
Okay. 2 and 3. Why I am balancing is independent witness and independent.
Yes.
3. Two names. 1 and 3.
1 and 3. Who is the scribe? Sir, being indifference.
To be allowed. This is merit to be allowed. Because PW3 is one of the independent witnesses and PW1 is the informant in this present case. This order is passed keeping in view that the petitioner is facing a serious charge and he has indefeasible right to defend himself. Mr. Hon'Ble and counsel for the state submits that the witnesses have already been examined in Vivek 2023. The petitioner's attempt is only aimed at prolonging the trial. Therefore, no leniency should be shown to the petitioner because the witnesses sought to be recalled have been subjected to extensive cross-examination and extensive cross-examination. In the application under section 311 CRPC, the petitioner has not even explained as to why the question sought to be put to them has been missed. And no further deem it appropriate to allow the application of petitioner under section 311 CRPC, which is PW1 and PW3. The trial court is directed to fix a particular date for re-examination for further cross-examination of PW1 and 3. PW1 and 3. And the petitioner should get a singular opportunity to further cross-examine these witnesses. The questionnaires, the trial court, it is open for the trial court even to evaluate the relevancy of the question to be put to the witness. It is made clear that the singular opportunity afforded to the petitioner is not availed for any reason whatsoever. The right to further cross-examine the PW1 and 3 shall be taken in. With this observation, the petition is partly allowed. Yes.
Okay.
Item 8.
Challenging the order dated
23/9/24 on annex of 2 lordships. So rejecting to my application 311 petition on the ground that the matter is in old record.
You neither you place the
Lordship,
evidence, nothing.
no, till now, the PW1 not cross-examined by the defense counsel.
Defense witness also.
The arising out of 138 in
The court found that many
So can you see page
opportunities were
11?
given to the accused person for cross-examination, but the same was not availed by the defense.
Page 11, Lordship.
11.
Yes, Lordship.
Yes.
Second para, Lordship. The accused person submitted that the complainant was examined as PW1, and now the case record is posted for arguments. It was submitted that the complainant.
Opportunity is given. Where from I get that opportunity?
One opportunity may be given, Lordship.
But where is the evidence? Where nothing? You have not placed on record.
Till now, no cross-examination, Lordship.
I know how many opportunity was given to you.
One.
How many opportunity was already given to you?
The problem, Lordship, the purport date she changed the argument. Advocate change.
I can't help you unless you tell me how many opportunities are given to you.
One more chance, Lordship.
I don't understand. How will I explain you?
Petition 311 petition भी नहीं.
300 application nahi, evidence nahi, nothing is there. One more
time, Lordship, can I given, Lordship, file the cross-examination to.
File relevant document, then only I can help you. How can I help you? File the document.
Next week, Lordship.
File the document. Let counsel for the petitioner seeks. It is 138 matter.
Yes, Lordship. NI Act, Lordship.
You must. I'll issue notice. Let us issue notice to opposite party. I'll issue just notice. 4 lakhs. Issue notice. Opposite party. Yes. And meanwhile, land counsel for the petitioner shall place on record the additional document to substantiate the case. Yes. Item 12.
Challenging the order of the executive magistrate governing for your lordship. The 144 proceeding, 163 of the BNSS Act, the executive magistrate pass in status quo order. Though have not jurisdiction to pass in status quo order, civil suit is pending. But they are not avail the remedy under order 13 rule 1 and 2.
Issue notice. Issue notice. Yes.
No status.
Next. 27.
My lord,
If I allow the IA, then the main petition is allowed. Wait. That's the final prayer. Yes.
Your lord,
take out the notice. Yes.
Your lord should also dispose of target the final proceeding.
27.
My lord, your lord should dispose of target the final CLMC application. That's why.
How can I do without issuing notice? You are agreed by a status quo order. I can't pass an interim order.
6 दिन ଭିତରେ ସାରିବା କଥା 57 ଦିନରେ ସେ appearance ପାଇଁ ଡେଟ୍ ରଖିଲେ status quo ଦେଇଗଲେ. ସେଥିପାଇଁ ମୁଁ କହିବା କଥା.
Then influx ହେଇଗଲା.
ନା ଡେଟ୍ ଅଫ appearance ଟାକୁ ରଖିଛି 57 days ପରେ ଯୋଉଟା କି 2 ମାସ ମାତ୍ର ତାଙ୍କର ଟାଇମ୍. ସେଥିରେ ସେ status quo order ଦେଲେ civil suit pending ଅଛି.
Next, what has happened to the proceeding?
Proceeding only for the
everything for appearance of the
appearance.
Go and appear then. Tell all these things to the court. Status quo order will be vacated. You have to go and tell that court.
After only issue notice on the
therefore, I have issued notice. Oh, where is that order? I'll dispose it up. Where is that? Which item? 12. I'll dispose it up and give you liberty to go and tell all these things to the magistrate.
Target coordinates 1 month is surgery.
Huh?
CLMC application number 5 of
No, I'll dispose it up main petition.
Yes.
Where is it? Order dated 9/2/2025.
Yes.
19
to 25.
Page 11. Relevant page is 12.
19. Yes. What does it say? In view of the circumstances, I'm satisfied.
That's 12 is that.
Ground for initiating section 163 BNSS. The year by order that the status quo is maintained.
There was jurisdiction. Civil suit is also pending.
Directed to file so next date of hearing. And next date of hearing is 17/4/2020. 17 is coming. On that day, it will be decided. You file meanwhile.
Yes.
I'll dispose it.
Yes.
Right. Petition is agreed by the order dated 19/2/2025. Passed by learned executive magistrate Jagat Singh Pur in what is this number? Case number?
CLMC number 5 of 25.
Huh?
CLMC number 5 of 25.
Criminal miscase number.
Criminal miscase number 5 of 2025 initiated by the opposite party against the petitioner. The petitioner is agreed by the order of status quo passed by the executive magistrate
Jagatsinghpur.
and passed by magistrate. Petition is also contended, the counsel for the petition also contended that after passing the status quo order, the executive magistrate, although allowed the petitioner to file the show cause, however, fixed the date for 17/4/2025. The magistrate should have heard the matter within 2 months. Within 2 months from the date of initiation of the proceeding. However, by passing an order of status quo, the matter was adjourned beyond 57 days.
57 days.
Beyond 2 months, beyond 2 months, beyond 2 months. Since since the matter is now posted before the executive magistrate on 17/4/2025, it would be expedient that the petitioner should file his show cause within show cause, urging all the point as has been raised in the present petition, and the executive magistrate is directed to dispose of the criminal miscase 5 of 2025 on the next date of hearing as has been fixed by him as actually fixed. Accordingly, the petition is partly allowed. The petitioners are directed to file show cause within this week. Within a week. The executive magistrate Jagatsinghpur is directed to dispose of the criminal miscase 5 of 2025 by next date of hearing. On the next date of hearing, already fixed. Dispose of. Yes.
27.
27
is an extension of time.
Extension of time.
Flag P.
Flag P. Yes. Extension time. By the order dated 19/7/2024. 19/7. The ordinary bench of this court directed the civil judge, senior division counselor to dispose of the civil suit CSR number 78 of 2017 by the end of February 2025. The letter P, na? C, the next the civil judge senior division counselor why this letter dated has addressed a letter to the registry of this court on 1/3/2025 seeking the extension of praying for placing the letter before this court for extension of time for disposal of the suit proceeding. Therefore, the therefore the matter is listed. Therefore, the present matter is listed today. For the reasons stated in the letter dated 1/3/2025, the time granted to the civil judge senior division counselor to dispose of the civil suit number CS number so and so is extended for further period of 6 months. 6 months, yes.
44.
44, yes. Non-appears for the petitioner in the interest of justice agent, yes.
53.
Non-appears for the petitioner even on the second call. Yes, 53, what?
Your lordship can like taken away any other day, Mr. Counts.
On behalf of the council for the petition, has been sought. Please matter. Entry to continue. Yes, sir.
Entry order, sir, continue.
54. Entry order is there, therefore you are seeking time. Otherwise, you will never seek time.
No, my entry order is there.
And yes. 54. Once you give entry order, that is the problem. Once you give entry order, that's the problem. Then all problems comes. Miscellaneous matter you will do. Admission matter. But once you get the entry order, then you have all problems. Yes.
Well, here the petitioners are in lodge. They have filed this present case.
An issue notice.
It has been
It was already.
What
it was
happened?
Already issued. Someone appeared.
Who is appearing?
Requisites are filed on 26/11/2022.
And Mr. Amulya Ratna Panda has filed.
All right. Entry order was sent. Yeah, is there, correct.
Mr. Amulya Ratna Panda has entered appearance on behalf of opposite party number 2. However, today for opposite party number 2. Leaves the matter for final disposal. Interim order of stay passed on 25/11/2024 shall continue. Yes.
55.
Don't appeal for
Covered now as Supreme Court, Honorable Apex Court has already decided this point.
55.
No, my lord, this item number 54. With regards to illness, what would be the approach of the court?
I know. It has to be stayed. Yes.
Correct.
If you would have come, I would dispute the problem. Yes.
55.
Is this 498? Matter was referred to the mediation center.
Matter was referred to mediation center. However, the report indicates that mediation has been unsuccessful. Leaves the matter for final disposal. Which one? 55.
55. Sorry, my lord.
Mediation failed. Mediation failed.
My lord. Petitioner repeatedly denied to take wife of the his wife. No.
Both are.
Anyway, mediation failed, it has to be heard. I'll hear it. Mediation failed, it has to be heard on merits. I'll hear it. Please the matter for hearing. After 1 week after the hearing. I'll hear it. Yes.
59.
No, this is a matter of settled between the parties, my lord. Just initially the affair lodged by the
sorry
informant under section 65 and 34. And
yes. What do you want?
My lord, I want to party was compromise between the.
But what are the offences?
Opting under section
376(1), 376(2)(n), 294, 506, 417, 420.
What are the allegations?
Allegation, my lordship, he has kidnapped the daughter of the informant. Yes.
Lordship, I am appearing on behalf of informant. Lordship, both the parties. And the matter is amicable settlement.
What amicable? What are the terms of settlement?
Lordship.
What are the terms of settlement?
Lordship, the victim is married between each other.
No, not married. I am not in the affidavit also, and I have already. They are not married at all.
Going to marry.
No, my lordship.
Marry and come.
No.
Marry and come.
They are not marrying each other.
What?
No, my lord, the fact is that, my lord, the informant is married to another. Tankara unmarried prastav already is.
No.
So that, my lord.
376 case.
Yes.
Kidnap and 376 case. It can't be fast like this.
420 is also there.
This court give indulgence to those people, those who are married and
Yes.
settled in their life.
Yes, already settled. Both the parties are gentle persons present. Tankara settled position, but
164 statement.
Yes, my lordship, I have.
And what about has he deposed before court?
No, my lordship, that has not been started.
What is
my
the
lordship.
stage of the trial?
appearance stage, my lord. Appearance stage. 10/6/2025 को appearance ଅଛି first.
How many accused are there?
My lord, 3 accused, but the other charge man 1.
Petitioner.
Not to charge to.
But
Not accident to accused. Only 1.
But he says that
Shakti
video viral by someone.
Yes. Initially, there is also high.
No, my lord, the video viral is not there, my lord, but
Have you read 164 statement?
No.
Read it. Yes, where is your affidavit? So, compromise affidavit. Terms of settlement is not written.
my lord,
Nothing has.
Nothing is written. Is he married to whom?
She is not married yet, my lordship. She is there, my lordship.
Where is the boy? Ask this girl. See, have you seen it?
Yes, my lordship, I have seen that.
They were in relationship.
Yes, my lordship, I have seen that.
They were in relationship, no doubt about it. And she is 18 years. She was 18 years when 164 statement was recorded. This boy was
Lordship, victim is present, Lordship.
22 years.
Yes. I've seen my lordship. She is 18 years old.
So then I think there is a marriage proposal somewhere else.
Yes, that's
Whether
what
this
they have
case-
tried in the
nothing
joint
is written.
affidavit.
That's the whole difficulty.
I just told him to write.
Can't advise them to how to
Joint
draft a petition, how to draft a affidavit.
I just told
How
them.
will you? For writing something, I have to write.
Yes.
You in the
Pardon
affidavit,
me.
you don't say anything.
Yes, my
What
lordship,
was
I
the
just
complete?
tell them.
Next time.
We were in love, now we are settled.
Yes.
Quash it. 376 and yeah. Who will quash if this is the kind of pleading? To file proper petition. Can't
Yes.
do it. Because see, 164 is very, very clear.
Yes.
Case is made out. How will you, who will help you if you don't draft it properly? I have to reproduce all these things. You have to tell me why, what is the terms of settlement?
Yes, ma'am.
The marriage is fixed somewhere else,
Yes, yes.
Yes,
tenancy
I
is
just told
creating
him to
problem,
write
something of
that.
that sort, nothing is needed.
I just.
164 statement, just give him, read it. If this is the 164 statement, who will give you handle this? They said everything against you, A to Z.
Yes, ma'am.
List it after next week.
My lord, fix that.
Read it, I will not advise you what to do, you know.
Yes, yes, ma'am.
Do it. Read
Yes.
164 statement and match your this thing.
Yes, ma'am.
Yes, next. 60.
My lord, interim protected, my lord.
Next week. Yes. Don't file the petition, anything, and yes, sir. Item 60. Yes.
It's squarely covered by the judgment of this court, my lord. I have given.
If Lordship permits, my lord, In the last occasion also, Lordship, my learned friend accept the statements that covered, but he has not enlightened me in any matters. Only see that this particular petitioner, Suni, this particular petition, Devendra Panda, in all the three cases, my lord, as well as the another case your lordship disposed of at page 50, at page 50 of lordship brief notes. The first case, 712, page 50, my lords. There they also the petitioner's case also there. So this gentleman, my lords, is a agent, my lords. He was working in different districts. Yeah, 217 is district pertaining to. Sorry, let me finish. He belongs to that. He committed the same problem in Jakshinpur. Another is same person in Kendrapada and another Cuttack.
How many cases he had?
That's exactly. I'm grateful for raising that question, my lord. That's why I expect my learned friend, my lord. Let him give a because he is in.
How many cases you have?
Your lordship,
give a list.
same issue. Four affairs lodged by different DIC.
If you come, you are an agent, you keep on collecting money.
No, my lord. I have been appointed by the OCCF. I don't have any role. Your lordship can't see the judgment of under Annexure 7. I have your lordship go through the judgment. Everything has been mentioned. My out of
can appreciate. What I suggest, it can be sorted out. My learned friend is in touch with Mr. Devendra Panda. Three petitions. Committed problems in 3 districts. No.
One minute, he says
it is there, my lord. So the prosecution's case.
Yes.
You own the case, it's a different issue. Because now, tacitly, I consider in one case where there was Ponda was appearing, thereafter he is away, now he steps in and they said, let him contact this gentleman, Devendra Panda. Let him get the list in how many other cases are pending against him, Lord. So all cases can be Let me ask the 3 officers coming from districts more.
You tell me how many cases?
The degree of complicity first.
Only 4 cases against the present petitioner, my lord. Out of 4, my lord, 1 already passed by this honorable court, and another 3 is pending, and where the discharge petition has been filed and which has been rejected. Thereafter, I have appealed your lordship.
Then the lordship, kindly permit me, my lord. I have got instruction in 2 districts, my lord. Another district.
But I don't know now. You let me file an affidavit.
No,
but I accept these 3 cases. I don't have any.
Series of asked case. Gote case there was appearing, my lord. I trust
you by tomorrow. You file it. I'll take it up on Friday, 11th.
And in the meantime, also that one case I could not get the instruction.
By tomorrow, you file an affidavit. At the outset, Mr. Das appearing for
only one for line I can appraise your lordship. On same issue, different DIC, they have recommended the names of the.
I understand. I just want to know how many cases. At the outset, Lieutenant Counsel for the business, Mr. Das, Sangram Das, submits that the petitioner is involved in multiple cases. Although in one of the cases, this court has already quashed the proceeding. On the strength of the judgment in that case, the petitioner is seeking quashing of the criminal prosecution in the present 3 matters.
10 to 3 other
3 matters.
10 to 3 other different data of the place of occurrence.
He further submits that nothing is coming forth on record as to how many cases are registered against the petitioner across the state. Mr. Kuntia, Lieutenant Counsel for the petitioner, submits that he would be filing an affidavit by tomorrow regarding the number of cases against the present petitioner. Let him do so by tomorrow. Please the matter on 11th.
Day after tomorrow.
Day after tomorrow. 11th, and advance copy to be supplied. And then I'll put it on 15th. Because he has to verify.
Exactly. No, in fact, I asked 2 officers from 2 districts, to ascertain what is the exact complexity.
Let him give the affidavit, you give it to them, verify, and if any other matter is there, everything will cost one day.
Yes.
That's good for him also.
Correct.
Yes. Okay. 15. 15. 15. Okay. Advance copy for the affidavit to be supplied to Mr. Das.
Obliged.
Yes.
Item 38.
38 regular, huh? 38, yes. Yes, sir. Yes.
Milord, I am appearing for opposite party number 1 and also I have filed counter.
Use the mic. Yes.
Yes, Milord. And it is submitted that, Milord. This suit property related to plot number 612, 613, 657 under Khata number 57 of Mauja, Sungura, in consideration of our work, published in 17/7/1984, attached being jointly recorded in favor of the present petitioner and opposite parties. In this regard, the opposite party number 1 had filed a CS civil suit in the court of Larent Additional Civil Judge Baleswar for partition of determining in his favor of the land, which is the subject.
Tell me the
matter.
point. You don't read it. Tell me the point. Yes.
First point, Milord. At the stage of final decree, the petitioner who are dependents number 2 and 3 in court below filed a petition under section 4 of the Partition Act for premature right paid for the present opposite party number 1 be directed to execute the sale deed in respect of the half of the suit land on the ground that the nature of the suit land in the homestead land of Sarada and the present opposite party number was stranger 1. But my I have submitted that the petitioner is not a, and the opposite party number 1 is not a stranger, and the opposite party number 1 is a half co-shares in the suit, that suit land. Also, the Larent court trial being heard from the both of side, maintenance of the section 4 of the Partition Act at the stage of final decree and ultimately reject the same by order dated 22/2014 followed by the specific finding that's Milord. Kindly similar triple I Milord. The stage of final decree, the petitioner under section 4 of the Partition Act is not maintainable. Further, trial court opined that the property under the consolidation ROR is the concedable and cultivable land. Nowhere is any portion land, the house and cow shed are standing over the suit land. The consolidation ROR was published in the year of 1984 to 1985, and the present petitioner who are dependent number 2 and 3 in the court below at no point of time ever raised any objection or paid for to set aside the consolidation ROR.
What are your points? You tell me. You are reading your counter. I will also read it. You tell me. Crystallize your point. What are the points? My point according to you is the application under section 4.
4 is not
maintainable. To support that, you show me what are they.
Milord, kindly see page 5, Milord. Page 5, para 14.
Page 5 of?
Para 14, Milord.
Page 5 of what?
In counter affidavit, Milord. Page 5.
Counter. Okay.
That the averments made in the 10, 11 and 12 of the CMP Hon'Ble deponent respectively submits that the law is well settled and it is clear meaning of section 47 of CPC. Executing courts cannot go behind the decree unless the decree is a nullity. 1984 IOLR 726 Milord. The case at hand at the stage of final decree, the Larent court below may not have competence to dealing with the matter at the stage of final decree regarding entertainment of application under section of 4 of the Partition Act. Otherwise, it amounts to reopen of the.
That is general principle.
So they have no rule for filing of after passing the.
Show me the judgment.
Milord,
show me the judgment which you are citing. OLR. Ramesh Kashinath judgment. Do you have the copy?
No, Milord, copy. Some.
That is not applicable. That is for execution. Section 47 CPC to file objection in execution proceeding. Here, final decree.
But he is relying upon 2-3 judgment. You have to bring the judgment. How can you see these are civil proceeding has to be heard properly.
Sir, I am saying in 2 grounds the Larent trial court has not considered. So in the outset I pray the matter should be
remanded.
The trial court to answer.
He is opposing remand.
He is opposing.
I would have remanded.
Then file this.
That's what the whole idea of hearing.
सी कहले फाइनाल डिग्री चलता बेले सेक्शन 4 पिटिशन जड़े दे पार ना जोटा कि भूल मुझे दीटा जजमेंट देवी सी कहले तुम जवाब
If you are seeking variation from the preliminary decree, then you can't do it. It should be in consonance with the preliminary decree.
ता भी नुहे फाइनाल डिग्री सरिया भीतर प्रिलिमिनरी डिग्री वेरिएशन हो पारो ता भी जजमेंट को देबे
That's what his case.
ना ना सी हम कहू जे जजमेंट अछि हम सपोर्ट रे डिग्री रो शेयर
Where are these judgment show me?
सर से जजमेंट भी अछि मु दे देबी मो पर तीनटा जजमेंट रखी
Very interesting. Both of you want to argue. घरे अछि दे देबी.
सर मु आनी छी जजमेंट दियो
दियो तू.
सेटा जेरस करबी की
I can't be heard like this. आपण
मु सर जजमेंट रेडी
आपण दीटा कॉपी आनिबे मते गुड कॉपी देबे ताको गुड देबे सी पढिबे हां सेमिते लेबो ना
सर मु जजमेंट सब आनी छी
आपण आनी छी गुड कॉपी कोड
हम तो शॉर्ट नोट करी जजमेंट सब
हां सेटा करो
नेक्स्ट वीक रखम सर
हाफ अटेंडली डोंट आर्ग्यू
ना ना मु सर मु
आपण प्रिपेयर हों तो आपण जो जजमेंट रिलाई करते जानू सो दैट वी कैन पास नॉट
सर नेक्स्ट वीक रखम
if you agree then I'll set aside shall I send it you argue all the points there shall I do that what do you want shall I set aside the order and send it back for rehearing remand
आउथरे हियरिंग मु राजी नहीं
आता
ठीक है
नेक्स्ट वीक
ठीक है ओके थैंक यू
और लगी